All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 8th. We have 9 bills on the docket, and we'll start off with Senator Heddleman with Senate Bill 790. We'll then move to 749, 710, 672, 784, 877, 673, 767, 768. So with that, before you start, Senator Heddleman, just real quick, we started our apologies for starting a little late. We're in the middle of session. We're that part of session where work groups and things like that are bleeding over, and other members are testifying in other committees. So I apologize for starting a couple minutes late here. So with that, we'll start off with Senate Bill 790. Senator Heddleman.
Thank you very much, Mr. Chairman and members of the committee. I'm Shelley Heddleman, a senator from District 11. This bill is about holding people accountable for if they obstruct a legislative or an executive branch government proceeding. The events of January 6th and events at other state capitals around the country show us that this is not hypothetical anymore, unfortunately. And acts of violence do occur against the executive and legislative branches. And these tumultuous times demand that our legislative and executive branches of government, co-equal branches of government to the judiciary, deserve the same protections. Currently in law, in section 9306, it says, a person may not by threat, force, or corrupt means obstruct, impede, or try to obstruct or impede the administration of justice in a court of the state. And these same provisions do not apply to the executive or legislative branch. So all this bill does is say that it should. It holds individuals accountable for obstructing or impeding an official proceeding of the executive or legislative branch of government through the same standards, through threat, force, or corrupt means. And it adopts the current legal standard imposed for the interference of court proceedings and only applies in circumstances where there's actual interference in a proceeding and does not apply to dissent, debate, or opposition to policies. So we believe that this bill will help to ensure that our government functions are protected and that the longest operating state capital continues operating according to the democratic ideals of our country and our state. I'm happy to answer any questions if anyone should have any.
Senator Castley.
Oh, I mean, in the last couple hundred years, I've no doubt we've had obstructions in this body. I'm just wondering how were those dealt with? I mean, I just find it would be ludicrous to assume that we haven't had some pretty serious efforts to obstruct the Senate, given the General Assembly.
When I was doing a little research on this, there are actually, and I don't have the citations in front of me, but there are actual parts of the code that prevent certain things from happening in our buildings when we are in session and when they're like you can't come and sit in, and it's pretty spelled out, and so this, but it doesn't go to this extent, and it doesn't, I think, apply to outside of the buildings.
I mean, my concern is, so you're putting this in a statute that's for the judiciary, and of course, the judiciary, there is no legitimate reason to protest courts. I know people are doing that, but it's totally illegitimate and counter to the entire foundations of our country to protest at the courts. And so there should be zero tolerance for protest, even spirited, perhaps even violent protests at the courts. And so you would want a $10,000 fine. By contrast, we fully expect to have pretty boisterous, sometimes physical even protest out and around this building, and the hallways are often get quite lively with chanting and stuff that you would never dream of tolerating in a courthouse.
Right.
So I'm just wondering, try to interpret.
So the state government
basket.
Article, so if you look at the fiscal note, it actually says it pretty clearly.
Okay.
If the state government article, that is this place that contains those prohibitions against disrupting or interfering with our proceedings. And there are currently laws on the books. You can be guilty of a misdemeanor, punishable by imprisonment for up to 1 year, and a $1,000 maximum fine. This beefs that up to also a misdemeanor, but up to 5 years and a $10,000 maximum fine. So, so the things that are precluded under that state government article are, for example, abusive language, disruptive noise, violent or threatening behavior, refusing to comply with a lawful police order. This just bumps it up, makes it more serious.
Have we had instances where the relief that's available under the existing state government article. It was felt that it was inadequate to protect the piece of this body, our ability to deliberate. I'm just not, I've been here for 8 years, I've had a single time where,
Right. Good question. I don't know. I haven't personally experienced that either, but I in those 8 years, we have looked around and seen, like, Michigan, what happened there, and I certainly wouldn't want something like that to happen there, to happen here, and would want to make sure that if those kinds of actions were
Yeah.
engaged in, that those penalties are
I mean, unfortunately, we
serious.
can't legislate intelligence or common sense, and that's too often what you find is that if you don't have intelligence or rational thought in the people administering the laws. But I remember at least a couple of cases where Trooper, was it Uno, was their predecessor, did have to get up and walk down to that end, and did have to, he was pretty effective at it, I must say. He had a rather commanding presence. So it's not unheard of in this room, but I don't remember a single instance where it went beyond him basically getting right in the person's face and saying, one more,
Right.
you're done, and the next one is the cuffs. So I never felt like this body was not, the existing laws weren't adequate. And we've had some pretty, we've had some really emotionally challenging stuff that you were sort of glad there was a metal detector at the front door kind of stuff
Sure.
in here. So, okay.
Absolutely. And no, I 100% agree with you. I just feel like over the past 5 years or so, those things have been ratcheted up and have escalated, and and we've seen those actions around the country, and so I just want to make sure our laws are sufficient enough to address those kinds of serious offenses.
I just don't, I hate to see this in with the judiciary. I just think it's apples and oranges. It's not the same thing. That what we would expect for the peacefulness of the courts and not the, I find it totally outrageous that people protest in courts or protest at courts or protest around courts. It's just immoral and despicable action. But I fully expect, most times when I come here, particularly on Mondays, I fully expect that there's going to be people outside with loudspeakers chanting that I can barely work in my office over the pet issue of the day. They're going to be in the hallways flooding it and making it difficult for us to get around. Hey, that's democracy. And so I just want us to be treated with the same level of civility that I fully expect to be in the courts. I don't think it really applies here, but.
So I 100% agree with you, but this bill is not aimed at that kind of peaceful demonstration at all. It is really aimed at obstruction and action, so.
Thank you.
No, I agree with you. There's got to be a balance between, courts, private residences, completely inappropriate, like big no-go. But here, you expect and you like the interaction, and this is the place where those voices should be heard, and the clash of ideas should happen here. And sometimes it's loud, and sometimes it's uncomfortable. So I want to make sure we strike the proper balance between providing that access to the folks that we represent and ensuring that their voices are heard and ensuring our safety. But again,
Absolutely.
courthouses and private residences are completely different altogether. And I think people that do that have stooped to a level that, we'll just leave it there. But Senator West.
Thank you, Mr. Chair. So I agree with the sentiments that have been expressed so far, but I've been here when we've had some very controversial bills the last couple of years, and the security presence in this chamber and outside is beefed up, and I assumed it's beefed up for a reason. Now, I've never seen the security people have to engage in protective action vis-a-vis members of the public, but if that should occur, it would be terrible, and if violence should occur, it'd be even worse. So this bill says, person may not by threat, force, or corrupt means. I think those are sufficiently distinguishing from normal
First Amendment.
First Amendment right attempts to be heard.
I agree.
That I can support this bill, and I thank the sponsor for bringing it.
Thank you.
All right, no further questions from the committee. Thank you very much.
Thank
We'll
you.
bring up your witness. We have Kevin Canali.
Good afternoon, Mr. Chairman, members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of Senate Bill 790 with an amendment. We agree. I hear this conversation. I think it's a great conversation. I think we're not talking about First Amendment rights here. We don't want to chill anyone's rights. We want to make sure that if there's a threat or intimidation, that is properly dealt with, and I think the bill spells that out very well. We would like an amendment to also make this bill to apply to local governing bodies, as we see the same amount of the uptick in threats, intimidations, disruptions at the local level. Again, we don't want, this is not about dissent or opposition. We think that we need to have some clear guidelines there and guardrails, and I think the bill does a good job of that, but we're happy to be a part of the conversation moving forward. If we can strike a balance here and make sure everybody's comfortable, we'd appreciate a favorable amendments report.
So, as a private citizens, you and I are on the street. You cannot threaten me, you cannot assault me, you cannot intimidate me. Those are all crimes, and you could be sent to jail for those. Sure. And of course, when we come in here, we don't surrender. And when we go into the town halls, we don't surrender those basic protections. What is it about the current criminal law that can be enforced within the town halls, the county councils? What is it about those protections that you believe are inadequate? I understand, on the judicial side, I understand, because in the courts, I don't even have a right to stand up and look threatening to the judge, right? If I just become boisterous in a threatening manner, this law would apply. So I'm just trying to find out why we need this extra, if this is to mean that you just can't engage in criminal conduct, well, then we don't need this entire, the current law. So it means something more. We're restricting your interactions more than you and I on the street. We're saying the legislature, there's even less of a right to interact with them. I fully accept that in the case of the judiciary. I'm just trying to understand, what is it you all feel that the current criminal code, which can give somebody 10 years for threatening them or for assaulting, why is that not adequate to protect your legislative bodies in the counties and the towns?
I mean, I think, I agree, I understand what you're saying, of course, and I think what we see is this bill adding a protection, and I think that in terms of, a governing body and during the course of official business, we see this as a reasonable bill. I understand what you're saying about the current criminal law, but I think if this bill is going to move, we'd like to make sure that we include local governments as again, we're subject to the same kind of stuff locally. But I understand your concerns, and we want to be part of the conversation to help move it forward and come up with something everybody's comfortable with.
Yeah, because, I mean, when I encounter you on the street, I've not said anything to you, and now you come and threaten me, so I can charge you with criminal violations. Now you come into the town hall, and I'm saying I'm going to take your money, I'm going to invade on your property rights, I'm going to invade on your parental rights, and now you expect to have more protections than the average people have on the street? It just galls me that here I have Mako coming in saying that we want to be able to protect our legislators more than people on the street, a greater level of protection than people on the street from this sort of intrusion on personal space. I find it outrageous that you all would, that's why you put cops in the chambers in case somebody does go over the top. But you don't have that on the street. It just seems odd to me that Mako would be in here saying that those of us sitting behind benches need to have greater protection than little old ladies walking down Main Street. That seems so odd to me, but I'll let you stand on your position, I guess.
Happy to follow up with you on that.
Yeah, so the way I'm looking at it, this is not about so much having, more or less rights than a regular citizen. It's that these types of bodies are enacted to do the people's work, right?
Yes.
And so we want to make sure that they're not impeded from doing that. When you talk about your local bill, does that include school boards?
I don't, well, so we're asking for an amendment to include local governments. We are not including school boards, but
So local government does not include school boards?
correct. We're talking about counties, municipalities.
Because I've seen them under attack
Yes.
and threat more than anybody, any other group, in the last couple years. And I find it odd that you would not include them in this bill.
So I think we'd be happy if they were. We don't represent the school boards. They have their own organization. I'm not sure if they submitted testimony, but we would not be opposed to including school boards in this bill.
But they too are elected.
Yes.
They too are exercising their formal function. And they too are, as close as we are to these folks sitting in this room. And I think they need to be protected as well
Absolutely.
if we're going to do any alterations.
Absolutely, I would
All
agree
right.
with you.
Thank you.
All right, seeing no further questions, thank you very much.
Thank you very much.
Thanks. And with that, that'll conclude the hearing for Senate Bill 790. We'll now move on to Senator Kagan with Senate Bill 749. Madam Vice Chair, welcome.
Sandy, I don't see it. Oh, got it. I got it. I got it. And I'm not going to, yep, I do. Thank you. Good. Great. Mr. Chairman, colleagues, for the record, I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville, and for the last 4 years, the chair of the Next Generation 911 Commission. You've probably heard me say that 3 people have died in my district when 911 has failed, and that when 911 fails, people die. You each were sent a copy several months ago of the 4th and final annual report from the Commission. It had 26 recommendations, one of which we bring to you today. Last year, the Senate unanimously passed 47-0, a bill that I sponsored on behalf of the Commission to create a work group to study and prepare for the launch of a statewide 311 commission. There was a great deal of enthusiasm in this committee, and Senator Watson, you're going to hear more about it now. But the House, when we went to the House and Government Operations Committee, they said, we love this, we don't think you need a bill. And so the advantage, frankly, of not having it statutorily created meant that our work group could meet really often and informally to get the work done. Before I start, I just want to say that I have an extraordinarily A-plus group of people who are with me today, and I need to give a special shout out to now Secretary, not Acting Secretary, Russ Strickland, who has been a great partner for 2 years. The administration has endorsed this bill, which is why Secretary Strickland is here, and Bill Ferretti, who even after retiring from Montgomery County's 911 Center and moving out of state, answered my call to come back and be with us today. They have been the 2 really fundamental leaders in this. The Commission Vice Chair, Steve Souter, the CEO of our 211 Center, Quentin Askew, and a bunch of people behind me are all going to be speaking. So why do we need 311, and why on earth would the 911 Commission be working on it? We've all heard stories, and we're going to hear one today, of the problems that happen when we don't have enough staffing at 911 centers. Our public safety answering points are usually understaffed. The workers, the 911 specialists, the courageous women and men under the headsets are enormously burdened, and too often people get a busy signal and someone is calling with a non-emergency item. 311 gives the option of being able to transmit and transfer non-emergency calls. So COVID and the climate crisis has reinforced and enhanced our awareness of the need for non-emergency phone lines. Where can I get a COVID test? Where can I get a vaccine? What day does my recycling get picked up? There's a tree that fell in front of my driveway and I can't get out. There's flooding that's affecting my city, whatever it is, and Secretary Strickland will surely offer even more examples. But we need a place with trained folks and with access to data so that they know what the recycling schedule is in Prince George's County and who the right tree pickup person is in Dorchester County. We've got to be able to have that data all in one place. The Maryland Joint Operations Center in MDEM, the Maryland Department of Emergency Management, would be the key location for 311 because they partner with emergency managers around the state and because they will have access to all of that data. And again, Secretary Strickland will be able to tell you more. On October 2nd, 1996, over 25 years ago, Baltimore City opened the very first 311 center in the nation. Now there are 6 311 centers in Maryland. In addition to Baltimore City, we have Baltimore County, as Senator Hedelman and Senator West know, and Senator Sidner. We also have Prince George's County, we have Montgomery County, Anne Arundel County, and St. Mary's County. all that have been providing 311 service. By bringing it all together in one location, we can lower the costs for those counties, provide the service for other counties that are not currently offering the service, and be able to be efficient and effective. I want to, before I forget, thank Senator Ed Riley and Michael Jackson, as well as delegates Sue Krebs and Terry Hill for their years of service on the 911 Commission and about 311 as well. We are aping the 911 system in a lot of ways when we propose to create this 311 system. So for instance, there's a 911 board that has cybersecurity and telecommunications and the disabilities community and 911 center directors and others. In the same way, we're proposing to create a 311 oversight board that would be composed of similar experts to help provide oversight and accountability. Let me share with you all, I have 2 documents. So one question that people ask is, how will I know which number to call? We've got 911 and everyone knows what 911 is, but how do they learn about 311? And when do they call 211? And you all know about the upcoming 988, which is a federally mandated suicide prevention hotline. How will they know which to call, and how will they hear about these numbers at all? So there's a marketing campaign that is part of this bill, but I want to bring your attention to the chart. So as you see, 211 is about social services. I'm hungry, I need a bed tonight. It's non-emergency social service. And Quentin Askew will talk more about the tremendous work that they do as a nonprofit that is statewide providing these services. 911 is a crime that's going on right this second, a fire right now, or an emergency. Grandma's having a heart attack, my baby isn't breathing right now. 311 is, I was at work all day and someone broke into my house. It's a crime, it's important, but it's not 911 urgent at this moment. So there are examples on this chart, again, everything from public transportation schedules to a streetlight outage, how do I pay my water bill, what are the hours of the library, where am I supposed to vote? Broad range. So the more key reasons why 311 can be so valuable for 911, in addition to offloading the burden of our calls, is the opportunity for training. Our 911 specialists, it's a tremendously challenging job, and most of us could never fathom the stress, the demands, and the skills that are needed. There are people who may apply and they may not quite be ready. So they could start as a 311 specialist and work their way into 911 specialist. Conversely, after a career of being a 911 specialist or after a supremely stressful experience with 911, folks can take a break and work at 311, mentor and be a role model for 311 specialists. So that's also exciting. We have a tremendous challenge with hiring, training, and retaining our personnel, and 311 will be easier and can provide a pipeline. It takes, just so you know, it takes 8 to 12 months to hire and train a 911 specialist and then to have them independently under a headset, and too many end up quitting too soon because of the stresses. You will be hearing from an amazing woman who spent over 35 years under the headset, and she will tell you the importance of 311. So I'm just going to share one other slide here. So a key component, whoops, rotate. Abby, I'm going to ask you to come up and help me rotate this, if you would, while I talk. So a key component is what happens to the 6 counties that already, thank you, my fabulous chief of staff. What happens to a county that already has 311? How are they going to be treated? And Bill Ferretti will answer a lot of great questions on that. I want to start the process. So ultimately, this is not a mandate. This is a gift. We want to offer it to all 24 jurisdictions, but if a county says, we like the way we're doing it just fine, they can continue to do that, but they're going to be need to comply with standards so that we make sure that anyone, anywhere in Maryland is getting excellent 311 service. They're also going to have to keep paying for it. So we think there's going to be an incentive to join the statewide, but we are leaving it up to each county. It's also possible that one of the 18 counties that doesn't currently have a 311 system may say, this is a great idea and we want to start one. We are giving folks until next July to decide and whether they want to opt in or opt out. And again, Secretary Strickland can talk about that. But this will give you an idea of the standards that we are creating to allow that our counties some flexibility. 311 is in about 87 cities. D.C., Baltimore, I already mentioned, Philadelphia, Pittsburgh, San Francisco, Los Angeles, a lot of big cities, and 16 counties. It's in 22 Canadian provinces and in Panama, Puerto Rico, Costa Rica, and elsewhere. There are some technical amendments that are in your folders, and they are truly technical, just making some little tweaks. For your consideration, the current effective date is July 1. If it's the committee's plan to move this bill forward, I might suggest considering June 1, just to give a little bit more time to start recruiting and appointing people to the 311 board, because we want them to start meeting as soon as possible to get this going. In addition to the folks who are going to testify today, the Anne Arundel County Executive has endorsed this. Congressman David Trone has been an incredible ally and is working on getting us federal funding. And because the governor has endorsed it, we also expect to have some money in FY24. You're going to hear from the Maryland Association of Counties, MACO, and Maryland State Police, and many others. So with that, Mr. Chair, colleagues, thank you. I know that I was longer than you might normally experience on a bill, but it's complicated and important and really is setting up a whole new public safety and customer service information center and system. So happy to take questions or happy to have my wonderful witnesses go first. Thank you, Mr. Chair.
I think questions for the sponsor before we go to the panel? Senator West.
Thank you, Mr. Chair. I guess my question is, sounds great. It's expensive. Have you been to the Budget and Tax Committee at this point?
Thank you for the question, Senator West. The plan and expectation, so first off, it costs money to buy the equipment, hire the callers, create a database, and maintain it. There are expenses. This is an entirely new government service system. And in addition to it being on telephone, we're also going to have a website, a portal. You're going to be able to live chat. And so it's not inexpensive. But first, I will say that I would suggest that is one of the best uses of our current surplus. It's heavier the first year to buy the equipment and stuff, and then goes way down. So as I referenced, I expect it to be in the governor's FY24 budget, and that we are expecting Congressman Trone to help us. We have actually talked to FEMA directly, the Federal Emergency Management Agency, and others, and he has been, and his staff have been wonderful partners for 2 years in talking about getting federal funding. So let me just say, there will be no 311 fee on your phone bill, and it will not use a dime of 911 funding. So those are two really important things for you to know.
Thank you.
Thank you for the question.
All right, seeing no further questions for the sponsor, thank you very much. We'll move on to your panel.
Thank you.
Mr. Secretary, want to come up? Yeah.
Chair Smith, Chairman Walt Stryker, members of the committee, thank you for having me here today. I'm here in support of Senate Bill 749, which will establish a statewide 311 system. I believe it's to be a major step forward in building a culture of preparedness and resilience in Maryland. And I want to recognize the outstanding leadership of Senator Kagan and Senator Riley on this issue. And she just told me I didn't introduce myself. So my name is Russell Strickland. I am the Secretary of the Maryland Department of Emergency
I
Management.
saw that one coming from a mile away.
Did you?
I saw-
Well, that makes me a lot more relaxed. So the bottom line is here, I have submitted written testimony for your consideration, which outlines why we think 311 is a foundational building block to a more resilient Maryland. Today, I'd like to highlight what I think is most crucial about a statewide 311 system. And that is basically that Marylanders need accessible, trustworthy information on both state and local government services on a daily basis. And this is under the concept that if it works well on a bright, sunny day, we know in emergency management as the disaster folks that when we have a disaster, we have a higher probability of it will be working well on a disastrous type day. A foundation of preparedness is knowing where to get information when disaster strikes. The statewide 311 system will provide that, replacing a litany of local and state individual numbers with just one that Marylanders can call no matter what their question or need is. So they'll be able to remember 311, they'll be able to remember 911. At the time of a crisis, that's essential. To that end, a statewide 311 system will establish a no wrong door approach, partnering with public safety answering points, county 911 centers, Maryland 211, 988, and the important government access points for various services and support for our residents. I want to stress that while this effort will require an investment, the increase in preparedness and resilience at the individual and community levels will pay dividends during disasters in both life and property protection. I appreciate the opportunity to share the Department of Emergency Management's position regarding this bill and respectfully request a favorable report on Senate Bill 749, and I apologize for going over. Thank you.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. My name is Bill Ferretti. I am a former director of 911 for Montgomery County, and I'm here in support of this bill. I was honored that Senator Kagan asked me to be a member of this work group to examine 311 and examine it in really a new way that hadn't been looked at by the rest of the country. As she talked about, it exists in many large cities, and some of those instances have actually expanded into counties, like it is in our state, and to a degree has fallen a little bit at regional, like in the Denver area, where it started to go a little bit outside the city limits to some degrees. They're looking at that as a concept. But this would be the first time in the country that we're looking at a statewide system. Why a statewide system in Maryland? And really part of it is to relieve the pressure on 911. So 911 is the number everybody knows. And I can't tell you, many times a day, a 911 call come in and the caller will say, this isn't an emergency, but, because that's the number they know. We've done a great job in 50 years of making that case. So if they had a 311 number and they knew that's what I call, doesn't matter where I am in Maryland, from the shore to the mountains, I can get non-emergency police assistance, or I can find out all the government services information. It would relieve the volume into 911, and at the same time, it opens up a great service to the residents of Maryland. And it's happening at a good time. We know through the work of the committee that a number of the instances in 301 in the state, their systems are starting to get to the point where they have to do a life cycle replacement. So if the state were to put up a system that those counties could then join, there would be a lot of synergy there and really a lot of opportunity to come together and avoid costs for all citizens of Maryland on having a statewide system. So I'd ask for a favorable report.
Good afternoon, Vice Chairman and, good afternoon, Chairman and Vice Chairman and members of the Judicial Proceedings Committee. My name is Quentin Askew, President and CEO of 201 Maryland, and I appreciate the opportunity to speak on behalf of Senate Bill 749. I would also like to thank Senator Kagan on her commitment and leadership with this bill. 201 Maryland supports Senate Bill 749, which establishes a 311 board and a statewide 311 system under the Maryland Department of Emergency Management to provide certain non-emergency information. The 911 system is one of the most critical government programs available in our state, and this bill will reduce the 911 non-emergency calls by expanding government 311 operations. In addition, the legislation requires the establishment of a 311 board. So this board includes 211 membership, which we appreciate. This inclusion and coordination with 211 will provide an opportunity to identify best practice ways to collaborate or perhaps even consolidate core functions, which will help with that sustainability. Like 211, 311 will serve as a valuable data capturing system so government officials can learn more about the residents of their community, whether it be noise, potholes, abandoned calls, or other immediate needs that we all need. This allows leadership in government to make changes in the community and provide the overall quality of life the community members in Maryland need. On behalf of 201 Maryland, I strongly encourage the committee to issue a favorable report on Senate Bill 749, and thank you for your time and consideration with this bill.
Good. It's live.
Senators, good afternoon. My name is Steve Souter, Vice Chair of the Maryland 911 Commission. It's a pleasure to be here, and thank you for your service. In this room, about 45 years ago, a different group of senators sat around this very table, perhaps not in these same chairs, and they debated something that was called 911. 911 was very new at that time, and the proposal before the senators was whether to adopt 911 in Maryland as the one single go-to number to report an emergency. And there was debate, of course, because there were some communities that said, well, my community is very comfortable with the 5-digit or the 7-digit number that was available at that time. But fortunately, it was the wisdom, if you will, of the senators at that time as they looked ahead to see a greater opportunity to serve Maryland citizens at the time of an emergency. Fast forward to today, we have a similar situation. The issue before you is not 911, but it's 311. And you've heard from the other people that have testified the value and the benefits that are derived by that. I would suggest to you that Maryland, again, step up to the plate, take the lead, show the nation that it can be done, and employ 311 in the future in the timeline that you've heard described. I think the ultimate outcome of that would be that Marylanders would be extraordinarily well served, both in time of routine as well as time of exceptional opportunity and exceptional events taking place. Thank you for your time, and I strongly ask that you support Senate Bill 749. Thank you.
All right, thank you very much, Mr. Souter. Looking to the committee for questions. Seeing none, thank you all very much. All right, Senator Kagan will bring up your next round of panelists. So could we please have Kirsten Newman, Brian Roberts, Tiffany Harvey, and we'll save the last two for the next panel.
Ooh, that's my glasses. Good afternoon, Chairman Smith, Vice Chair Wallstreicher, members of the committee. My name is Tiffany Harvey, and I am Vice President of Government Affairs and Regulatory Affairs for Comcast in Maryland and Delaware. We are here in support of Senate Bill 749. Let me put my notes out. And we would ask that the committee issue a favorable report. My predecessor, Sean Looney, was a participant on this work group for the past 4 years, worked hand in hand with Senator Kagan and the other members of the commission on the work that they did to push forward 911 and Next Gen 911 in Maryland, as well as the statewide 311 system. We stand here on recommendations that have been made by the full report, as well as this recommendation, which contains the system, the setup and the creation of the 311 system. So the other members, I think they're the experts on it, and they can answer all your questions, but we would stand behind the work that was done from this committee and this commission, and we would ask that the committee issue a favorable report. Thank you.
Chair Smith and Vice Chair Waldstreicher, Senator Kagan and Senator Riley. Sorry, I'm tall. Thank you for allowing me to share my story today. My name is Kirsten Newman, and I have a daughter, Vivian Newman. She is 4 years old. I'm here today because of my recent negative, almost deadly experience with 911. In order to give you some perspective, I need to share with you a brief synopsis of Vivian's medical history. Vivian was diagnosed with stage 4 neuroblastoma in 2019 and spent 2 years undergoing chemotherapy, multiple surgeries, radiation, and immunotherapy. In January 2021, she was pronounced cancer-free. This past year, she's participating in a clinical trial at a Memorial Sloan Kettering in New York in hopes that it will vaccinate her body against the cancer. The clinical trial includes a series of shots and creates temporary flu-like symptoms, including fever. Vivian received her final shot on February 15th, and we were cleared to drive home that evening. The following day, she developed a low-grade fever, which was expected and lasted throughout the day. Around 3 p.m., she suddenly stopped breathing. Her face began turning blue, and she started to seize. I grabbed my phone and dialed 911. I was greeted with the following message: "I'm sorry, we are experiencing high call volume, please hold." I was then put on hold while my daughter continued to seize, and then it disconnected. This happened twice. From the time of my first phone call, 5 full minutes passed before 911 got back to me. By this time, our babysitter had reached a dispatcher. Unfortunately, it still took another 15 minutes for an ambulance to get to me. My daughter was barely breathing and seizing for 20 minutes. Vivian is okay, and her oncologist believes she had a complex febrile seizure. However, we are very lucky she does not have any lasting neurological damage, considering the amount of time it took for an ambulance to get to us. I have subsequently learned that our county, with a population of almost 600,000 people, only has 6 dispatchers when fully staffed. Also, when fire or ambulance is needed, the call is sent to another center with fewer dispatchers. These people are working 12-hour shifts with no mental health support, are underpaid, and burn out quickly. The Anne Arundel County is one of the few counties in the state without a consolidated call center. I'm asking you to please support SB 749 so we can lighten the load on our 911 systems and prevent an accident like what happened to my family from happening again. This is literally a life or death situation for every resident of our county. Thank you.
Ms. Newman, I'm glad your daughter's as well, and thank you for testifying and sharing your stories. Thanks. No, I was just saying thank you for coming, and I'm just delighted that your daughter's doing well.
Do I really have to follow that?
It's hard, I know, you know. It's up to you.
Good afternoon. Thank you, Mr. Chairman. Thank you, members of the committee. My name is Brian Roberts. I am the Program Director of Montgomery County's 311 operation, and I'm here to support SB 749. A statewide 311 system would make the delivery of government services more accessible to people who live, work, play, and run businesses in Maryland, would provide support for smaller Maryland counties, relieve some non-emergency call volume from police departments, could save existing local jurisdictions significant investment in information technology, and possibly create a new career path for 911 agents. Let me give you an overview of how Montgomery County's 311 operation works. We provide a single contact number and website for non-emergency requests for government information, services, and complaints. And there are 2 major types of calls that we handle. General information, which is about 71% of the calls, and fulfillment, which is 29%. General information are questions we can answer directly out of our database of information, and fulfillment are requests that have to be fulfilled or handled by the county departments, and include things like information from experts, requests for specific services like a stop sign that needs to be repaired, and that sort of thing. Our hours are from 7 a.m. to 7 p.m. Monday through Friday, and the website is of course available 24/7. 75% to 80% of the calls are about trash and recycling, social services, permitting services, taxes, and housing. That's now during the COVID period. Pre-COVID, mass transit was number 1. So we take a wide variety of calls. Take about 40,000 to 45,000 calls per month. We've got 40 customer service representatives budgeted. Usually 30 to 32 are on the phone at any given time. And during the increase in call volume during the COVID period, we've had contractors and employees assigned from other areas. We also support emergency response, and we do a lot of data collection and analysis for continuous improvement. So our experience in Montgomery County with 311 operations has been very positive, and I think 311 can be very positive for the whole state if we take our time and direct resources where they're needed most. And I urge a favorable report for SB 749.
Excellent. Thank you very much. All right, see no questions from the committee. Thank you. All right, next we'll hear from, is Susan Greentree here and Kevin Canale.
Oh, Jesus, okay. Good afternoon, Chairman and all members of the committee. I appreciate your time here with us today, or with me. So, my name is Susan Greentree, and I have to tell you, I was very moved by that woman's testimony, not only because I was for 35 years, a little over that, a 911 specialist, but because I worked for Anne Arundel County and retired 2 years ago from there. So that hits me particularly hard. So in any event, the job of a 911 specialist since roughly 1985 to now is vastly different. The population in Anne Arundel County alone has grown 48%, and the population in the state of Maryland has grown 38%. Add to that the implementation of cell phones and how many just in your household, if you've got a spouse and a couple of kids, there's that many phones you have. So the volume for cell phone calls has grown exponentially more than just the population. Without a doubt, we have not kept up with that growth. When you are having a medical emergency or your home is on fire or someone is breaking into your home, you need your call to be answered immediately. The fact that there has been an accident on 695, cars have pulled off to the shoulder, and there's 15 calls flooding the 911 system because of that one accident and you're sitting in queue waiting for that next available operator to answer your medical or fire emergency. This happens all the time through no fault of the PSAP. At Anne Arundel County, if I answered a 911 call and it was not a true emergency, and there was another 911 coming in, I was instructed to put that call on hold and answer the next call because that may be an emergency. So now we've got the person who had to wait to get answered who has an actual emergency, and now I've got somebody else sitting on hold waiting for me to come back and process their call. All around, it is not good customer service for the citizens of Maryland. It's a system problem, and the system is out of touch with today's need. Maryland needs a statewide 311 system to take the burden off of take the burden of the non-emergency calls off of the 911 specialists so they are available to immediately answer calls related to life and property emergencies. Citizens call 911 for parking complaints, utility issues, animal complaints, destruction of property. I believe 911 can be a resource for that. Also, 311.
Do you have a quick moment?
311, had that been available when I retired 2 years ago, because I just couldn't listen to what I was listening to anymore, I may very well have shifted to another job because I loved that job. Instead, I retired and sought out other work. I urge a favorable report on Senate Bill 749.
Excellent. Thank you very much.
Good afternoon, Mr. Chairman, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of Senate Bill 749. You've heard about all the great things in this bill. I'll just say from a county government perspective, this is about all boats rising. We want to have the same level of service all the way from Garrett to Worcester County. We think this bill is the right mix of flexibility for counties who have a 311 system and want to keep it, but also providing counties that don't have those resources with access to them. This bill is about streamlining access to our residents, non-emergency information, as well as information about government services, as well as reducing the burden on our 911 centers on those non-emergency calls that clog up and jam the system. So with that, Mr. Chairman and members, we ask for a favorable report on Senate Bill 749.
Excellent. Thank you very much. We'll look to the committee for questions. Senator Huff.
Which counties don't currently have this?
The 6 that do, Senator Huff, are Baltimore City, the very first in the nation that's been operating for over 25 years, plus Baltimore County, Montgomery County, Prince George's County, Anne Arundel County, and St. Mary's County. And the testimony, and I can catch you up if you want, but the testimony would allow them to either continue doing it and functioning their own independent 311, but at a higher level and complying with statewide standards, or they can opt in and they would be included in the statewide system.
All right, so just a question. Actually, I was over in your committee, so we were.
Yeah.
I'm looking the fiscal note.
Yep.
I mean, it's a pretty big fiscal note.
Yep. Senator West had asked about that, and it's a totally fair question. So first, it's an important new statewide service that is even more critically needed that we learned during COVID and through the climate crisis, and people need access to information, and we need to lighten the load on 911. Two things, because the governor and the administration has endorsed this bill, we anticipate state funding being included in FY24, and I've been working with Congressman Trone for almost 2 years on outreach for federal funding, which they are very optimistic about, and we've also had recent conversations with the administrator of FEMA, the Federal Emergency Management Agency. So one of the things that I'm clear on is that there will not be a 311 fee on your phone bill. This will not take a dime from our 911 centers or fees from that.
Okay. What about, because it says this bill has a local mandate, it says. Is this going to cost the locals money?
No, it's actually the exact opposite. It will save the locals money. So for the 18 counties that do not have 311 right now, they get a birthday present. They get a whole new system to serve those, to be able to serve folks who don't know how to navigate the bureaucracy of their county.
Okay.
Maybe they don't have Wi-Fi, or maybe their Wi-Fi is down in a power outage, or they don't speak English or have trouble navigating. They may have a disability, they can't use the website, and we all know that a government bureaucracy can be tough to navigate. So calling 3 digits and getting connected to the information you need or the person who can solve your problem, where do I vote? There's a tree that fell down, there's a stop sign that needs to be replaced, whatever that is. They're non-emergency numbers, services, but yet right now, because they don't know where to go, they're calling 911.
Yeah. Yeah, I remember. It's just so funny because it's changed. I was explaining to my kids the other day that I don't even know if it still exists, that you could dial a number and get the time and I think it was the time and the weather
Right,
or something like that
right.
they had.
411.
Yeah, and we used to dial, information. We used to dial that
Yeah.
all the time for that was like your Google, like in the 80s.
Right.
I don't even know if that's still operating or
I'm not
whatever,
sure.
so. All right, thank you very much.
Yes. And Senator, we also, there's a chart on when to call 211, 311, 911, and 988, because there will be a marketing campaign, which is important, so people know when to call which one. But super important is that they're all going to be interconnected. So if you think it's 311 and it really should be 211, it's going to be very easy to transfer. And that was why the importance of having Comcast and other telecommunications and cybersecurity experts as part of our work group was so critically important. And they have assured us that this will be seamless and easy to
Is
do.
that in your testimony, that chart?
It's
I
in
see
the.
it, I see
Yes,
it.
it's in your folder.
Okay, excellent, thank you.
Thank you. Further questions for the sponsor or the panels that have been here? All right, seeing no further questions, I think everyone has testified on the legislation.
I believe that's right. Thank you so
Okay,
much.
that concludes the
Appreciate your
hearing on Senate
consideration.
Bill 749. Thank you, Madam Vice Chair. We'll now move to Senator Patterson and Senate Bill 710. And if you'd like to bring your panel up, Senator, please feel free.
Easily, loudly, quietly. Good afternoon, Mr. Vice Chair, members of JPR. Thank you very much for this great opportunity to introduce, get my glasses on, Senate Bill 710. Senate Bill 710 seeks to reform some wraparounds, if you will, in terms of finding some solution for some loopholes in the criminal justice system. It's a bill that would bring a little parity to justice, if you will, and we certainly hope that you will give it your full consideration. The bill passed last year in this committee, which was a similar type bill, Senate Bill 201, passed, and certainly I want to give kudos to the vice chair who sort of helped me through on the House side to get the bill through at the 11th hour, but we won't use my time to talk about that bill. That bill has passed in its history. Today, we want to talk about a new arena in terms of things that we can do to help this population of individuals. I am very happy and very pleased and fortunate to have an expert panel. I've listened in on them on some other legislation throughout the General Assembly, and they are here today, and they are going to be put for any specific questions that you might have, and we will take it from there. And I guess, Mr. Chair, if it's okay with you, I'd like to start with my lead sponsor.
I'll take it.
Oh, sorry?
Oh, was it Mary Lou?
No, no,
Okay, just checking, just checking.
Who's it going to, Chris?
Yes, it's me.
Okay, it's going to be Chris Sweeney.
Chris. Close, we're good. We good.
It's not Sweeney?
Go ahead, Mr. Deuce.
You're good, you're good.
Okay, all right.
Thank you, Senator Patterson. You're good to go. Thank you, sir. Thank you, sir. Thank you, sir. Stay there. Okay. First time testifying in person. It's been a minute, this session. So let me just set some things up. Phenomenal. My name is Christopher Dews, and I am the Senior Policy Advocate of the Job Opportunities Task Force, where our mission, as always, is to help lower-wage workers advance to higher-wage jobs. We are in support of Senate Bill 710. It's a rather interesting bill. The whole purpose of it is to reduce the waiting periods for non-violent felonies, misdemeanors, and to kind of modulate the non-conviction statutes to kind of fall in line with that. The reason why we're doing this is really about employment. That's how JOTF is looking at this. 1.5 million Marylanders have a form of a criminal record that will appear on a background check. In 2019, 75,000 Marylanders applied for a criminal record expungement, to let you know just that this is a pretty big issue. And 15,000 Marylanders are released from state prisons every year. 1 out of every 3 returns to Baltimore City. Within 3 years, about half of that population is going to recidivate. 60% within 5 years. And the number one reason for this is lack of employment. About 60% of those who have been released from incarceration remain unemployed within after 1 year of their release. In a nutshell, this is because of background checks. We know that employers want to make sure that they're getting the best persons that they can possibly hire. But unfortunately, a population that has served their time, that is basically going about and just trying to live their lives, are finding themselves blocked from access to housing, employment, education, occupational licensing, and much more, simply because they had a record that they already served their time for. So what this piece of legislation simply does, in a nutshell, it will reduce the waiting period for misdemeanors from 10 years to 3 after an individual has completed their parole, probation, and any other type of mandatory supervision, as is in compliance with Maryland state law. It will reduce the waiting periods for a certain type of misdemeanor, second-degree assault and common law battery, from 15 years to 5. And it will reduce nonviolent felonies, there are 5 that I can name off the top of my head, from 15 years to 5 as well. We urge a favorable report. And I'm open for any questions you may have on the bill. Kind of got the technical details.
Yep, we'll do that after the panel.
You got
Mr.
it.
Dews.
Thank you, sir.
Christopher Sweeney.
Thank you very much, Vice Chair Wallstreaker and members of the committee. It's a pleasure to be here today. I'm Chris Sweeney. I'm a staff attorney at Maryland Volunteer Lawyer Service. I manage our workforce development project where I assist job trainees with removing barriers to employment. Through that program, I've assisted over 700 people with filing for expungement. I want to ask you to imagine a young person in your life, maybe a relative. Imagine this person has been caught stealing even just a candy bar from a convenience store. Do you think it's fair, more than 10 years after that happened, for an employer to see the words theft conviction on a job application? That is how expungement currently works in Maryland. Now, even if a person were to be convicted of something more serious but nonviolent, Is it fair 15, even 20 or more years after the incident for that person to be denied housing, to be denied employment that could otherwise be the key to them keeping their life on the right track? And I think even more importantly, the expansion of eligibility for what can be expunged is crucially needed. The current statute omits a vast number of very minor offenses that leave thousands of people in our state with a permanent criminal record for life. Just by way of example, things I've seen on my client's record are convictions for things like riding a bicycle on a sidewalk, fishing without a license, and certain types of public alcohol consumption. Those things could not be expunged. Criminal record expungement means employment and housing. When someone has already been punished by the courts properly, they've paid their debt to society, they've served their time, they do not need to be continually punished for years and years. I, for one, do not want Maryland to be a state where people are forever judged by their worst moments. I truly appreciate the opportunity to be here. I urge a favorable report with sponsor amendments also. Thank you.
Whomever would like to go next.
Good afternoon. My name is Mary Janice Davis, and I'm with the Office of the Public Defender. The Public Defender's Office has been assisting our clients for more than 15 years at our weekly clinics and our annual Back to the Neighborhood event, where we have seen firsthand what has happened, and that's why we're here to support Senator Patterson's Bill 710 for favorable recommendation and some amendments, maybe suggestions. But what I would say is that since 2007, the General Assembly has consistently passed expungement laws for the benefit of all Maryland citizens. And we all know how those benefits relay into more work, better housing, and educational opportunities. One of the reasons why, and Chris talked about, Mr. Sweeney talked about this, was how it broadened the category of misdemeanors that would be eligible. It is very frustrating when you're talking to a client and you're trying to explain to them why this misdemeanor is eligible, but not that one. No, that one can be, but not that one. And what this does is eventually I just throw up my hands and I just say, well, that's what Annapolis picked. Because there is really no rhyme or reason to some of the misdemeanors that have been chosen. And I think it's very important that the expungement statute be precise and everyone can understand it, including the judges. And that's why I think some of my suggestions, the reason why I'm asking for some amendments, maybe more suggestions, it has to do with one of them being the fugitive warrant. Fugitive warrants generally are not invalidated, they are dismissed. And so it's important that that gets changed, so if we do pass it, that there's no judge that says, well, this was dismissed and not invalidated. Another example would be the PBJ, which I think is going to be discussed later. And the third thing that I would just say is the common law offenses, attempt, solicitation. I just recall one hearing that I had with a judge where it literally took me, I had to actually show that point in the statute about the attempt before the judge would actually grant it. So I would just ask for that part to remain. Again, I'm
Thank
here
you.
to support Senate Bill 710, and I am open for any questions.
We appreciate it.
Thank you.
Thank you. Thank you, Vice Chair and committee members. My name is Charlotte Ahern, and I am a staff attorney at Maryland Legal Aid. Maryland Legal Aid represents low-income families and Marylanders throughout the state. Senate Bill 710 will directly impact communities that are subject to over-policing and overcharging and other forms of systemic oppression. I just want to reiterate and emphasize the prior testimony and add a couple of issues. Probably the number one issue that my clients face in relation to employment is having a criminal record. It's not only my clients, it's 25% of Marylanders have criminal records. That's 25% of your constituents that are touched by the criminal justice system. And the the way in which people reenter society, the foundation to be successful is to have gainful employment and to find stable housing. If you are unable to find gainful employment, then you are also unable to have stable housing. When you have a criminal record, the likelihood of getting a job significantly decreases, particularly in that 2 to 3 year time frame. The risk of reincarceration and the risk of recidivism is extremely high. And it's also during that 2 to 3 year time frame that unemployment is the highest for those individuals that are trying to successfully reenter society. Unemployment for individuals that have criminal records is 5 times the national average. I believe also the risk of homelessness, it's around 12 times the national average for individuals that have criminal records. Senate Bill 710 will drastically help your constituents, and if your legislative purpose and your legislative goal is to employ Marylanders, then Senate Bill 710 will put those words into action. So we ask a favorable report. Thank you.
Thank you so much. Senator Bailey has a question.
Thank you, Mr. Vice Chairman. I was going to ask Christopher Dews.
Yes, sir.
When you gave us the examples, you sort of gave us, this is door number 1, door number 2, door number 3. Are all 3, as we discuss this with the committee, are all 3 as important as each other? Or if you could prioritize this as we look at this, which ones are is the most important for you? Which one will affect the most constituents and be able to get people back to work?
Okay, first of all, thank you for the question, Senator Bailey. If I had to put them in rank, and I'm sure my other panelists may have other comments on this, I would argue that reducing the misdemeanor window, because I think that expands to, as you may be already familiar with, DNR charges as well. It just has a wider range of people. So I would argue that the reducing the misdemeanor window, like other states have done, from 10 to 3, I think would be number 1. I think number 2 would actually be another form of misdemeanors. I call them contact misdemeanors. This is second-degree assault, common law battery. Reducing that from 15 to 5, I think, is also rather important because many people, there's not a strong distinction between second-degree assault, and it has a wide gambit. So I would say that. And then, of course, I would argue that lastly would be probably the nonviolent felonies, if I had to put them in rank. Now, of course, they're all important. Getting rid of all of them, or at least reducing the window, is going to help hundreds of thousands of Marylanders, but I would definitely say all misdemeanors in general, and then the contact misdemeanors, and then the nonviolent felonies.
And I appreciate that because I'll have to say, had communication with a parent who had received a charge. It was a natural resource charge, a loaded gun on a vehicle, and it was like 9 years ago. And they were flagged and couldn't go on a school trip, and they couldn't participate in the school because of that charge that was, he leaned his shotgun up against a ATV and received a citation for it. Now he can't participate. And definitely think that would be something. The other thing is, in the realm where, I represent, we do have people that have received violations such as oysters and things like that. And we have people that have a hard time getting back to work as a result of it. And I just wanted to make sure that that dealing with misdemeanors would clearly impact that and allow us to get some of these people back to work as fast as possible.
100%. Thank you for the question, Senator.
Thank you.
Sounds like people coming together a little bit on this bill. Senator West.
Thank you, Mr. Chair. Mr. Dews, nice to see you again.
Nice to see you too, Senator.
You and I worked together on a bill last year, which was somewhat controversial, as I recall. But we got it passed.
Indeed.
So this is not the first time this bill has come before us. We've seen it in prior years, and each time the judiciary has come in with a strong objection. And again, this year, the judiciary has submitted a lengthy memorandum objecting to the bill. I wondered if you've seen that, and if you have, would you be able, not now, but could you prepare some kind of a written response to the judiciary, talking about their concerns and giving us information which would be relevant as we consider this bill later on? In particular, the judiciary has emphasized that it is not effective effectively able to expunge one charge in a unit. So if a charge, if there are like 3 charges against the defendant and one charge is expungible and the other 2 are not, they said it's extraordinarily difficult to go through everything page by page and the entire trial record and everything else. And in order to expunge that one charge whenever it appears, and apparently it appears lots of times in the typical case. So I'd be interested in your response to that.
Yes, so, that's 10-107, that's the unit rule. It's a very complicated, kind of, I want to say legalistic kind of trap. But I would say to the responses from the members of the judiciary, I have not had the opportunity to read their testimony. What I will say is I just want to be clear, because one of the concerns that I did hear through the grapevine was, when does the waiting period start? That's one of the things, and I just want to be very clear. We're talking about, for example, as Mr. Sweeney had mentioned, this is after an individual has completed their parole or probation, after they've finished their sentence, and they are basically back on the street. So this is, to be clear, for misdemeanors, a 10-year window that begins once they are totally free. So I just throw that out there to say that we call it a street sentence. That's the kind of common colloquialism. So for us, yeah, we can definitely repair a response to that. Also, when it comes to the unit rule, I know that that's a little more sticky, and we are willing to work with committee members and bring them into the conversation, members of the judiciary, so that we can kind of hammer out those details as well. We're also a part of a partial expungement work group that is looking at how do we allow for partial expungement, and I think Mary Denise can probably has more to say about that.
Hi. I know Mr. Cox is also on the committee, and he can also, I don't think there's, to be perfectly honest, right now at this moment, I don't think there's a clear answer between either side of how to allow partial expungement to happen. I know that there's definitely a movement, and I definitely think there's a lot of people that would like to see it happen, but how to reconcile what the advocates would like to see and the concerns that the judiciary has, that is still being debated. I know that there was a final report, but I can't say that final report came up with the clear answer. It came up with suggestions.
Right. It sounds to me as if the MDEC system has to be finished completely, and then work can be done on the next generation, which would include the ability to partially expunge, but they're not there yet.
No.
And that's the message we've been getting from the judiciary for the last several years. It's going to take time, and you need to give us the time to get things in order, and then it will be possible to do that.
But is but this isn't in this bill, Senator.
The partial expungement?
Partial expungement's not in this bill.
Oh, okay. Well, it's in their testimony.
Oh, okay. Yeah, no, I'm sorry. I'll say this really quickly. Yeah, no, this bill is simply just looking at the waiting periods and trying to reduce those. So if there is a connection between that and the unit rule, then I'm sure it is, but that's not what this bill necessarily is. I'm sorry if I didn't answer that properly.
No, that's fine. Let me get you a copy of this, and then if you could, in due course, get me a response, it would be helpful.
Yes, sir.
Thanks.
Thank you.
Thank you, Senator Castley.
I just want to make sure I understand this bill right. So if I defraud old people, and I'm a young person, I defraud old people, take 15, 20 grand for them, I get a year and then a year of probation, then a year after that, my record is wiped clean. I have no record, there's no public record that I defraud old people and take their money, right?
I don't think that would be how that works. I think, as an example, because this is a true story, young lady.
It's not a crime of violence. I just get their accounts. I don't beat them up or anything. I just take their money by defrauding old people. So it's not a crime of violence, which is they're accepted under here. So it's just theft. I'm just an evil person who steals their money. So if I get a year and I do a year of probation, and now a year after that, it's 3 years later, my record's wiped clean. Isn't that what this bill says?
No, that I don't think that's what this bill is saying.
How
It
is
would
that
say,
not?
so if you actually were to turn to page 8.
Look on page 8, yeah.
Yeah, you're on page 8. Yeah, 5 years. So this would be, so currently, what the charge is talking about, I believe it's theft, felony theft. That would be, right now it's 15 years. So after you've completed your time, parole, probation, whatever you need to, whatever the court has mandated, then a 15-year waiting period would start. right? So now you've finished everything. You have served your time, and now you are back on the streets. So you're just living your best life. And now we're talking about, what this bill is simply doing is reducing the waiting period after you have done everything, all of your court mandated everything, from 15 years, which is what current law currently says, to 5 years. Not 3, I'm
Why do you say
sorry.
it's 5 years? It's the date you satisfy the sentence, and including any period of parole or probation, or 3 years after the conviction, whichever is later. So if you're if you got a year to serve and a year of probation, you finish both of those up, and now your record, and 1 more year goes by, your record's wiped clean, and there's no record that you defraud old people.
So Senator, as to just going away, this is not automatic expungement. This still requires a filing. And it, under the statute, which is, you have 10105, and then you have 1010. And these convictions fall under 1010. And under 1010, it's not like the petition's not treated like a no-pros or a dismissal. The convictions, actually, the state's attorney has the ability to object. The victim has the ability to be part of the hearing. And then if you look, it's kind of not in the bill, but if you look, it also says
That's always a
that-
problem with these. We don't get the whole law. We just get the
Oh,
piece that
okay.
you
So,
changed.
but the
pull.
judge has the ability to consider the nature of the individual's rehabilitation, and does this serve justice? So it is not automatic. It's not simply 5 years, you file a petition, it's going to be expunged. If the state's attorney or the victim feel that this person should not get this expungement, they have the ability.
I'll take a look at the full law in context. Thank you.
Okay, sorry. Okay.
Thank you. This was a good discussion. Further questions for this panel? All right, seeing no further questions, we'll call up the next panel. Jessica Emerson, Harold Coleman, Quiana Johnson, Antoine Quarles.
I believe the last 2 witnesses, I'm sorry, were written only. I apologize if they appear as oral.
Okay. Harold Coleman, Elena McWilliams, Nicole Hanson-Mundell. Go ahead.
Great. Good afternoon, Vice Chair Waldstreicher, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law. In collaboration with the Maryland Volunteer Lawyer Service, the HTPP works to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking. I am also here in support of SB 710 with sponsor amendments. In addition to the points my colleagues have already made, I want to reflect a bit more on the intent of expungement waiting periods, which have historically reflected the belief that individuals should only be eligible for expungement after successfully rehabilitating themselves, which is traditionally shown through a period of crime-free behavior. However, many states have actually have since shortened those expungement waiting periods in recognition of data that indicates the inverse, which is that record clearing actually plays a significant role in rehabilitation. And I think Christopher highlighted that in his earlier testimony, meaning that lengthy waiting periods may actually contribute to recidivism rather than rehabilitation as once believed. SB 710 would support this research by reducing waiting periods for both non-convictions and convictions alike. I'd also like to note that criminal records are both a predictor and the result of victimization by a trafficker. Like all individuals with a criminal record, criminalized survivors struggle to obtain safe housing and gainful employment. For this population, however, these consequences carry with them the additional risk of continued exploitation by a trafficker. In recent years, Maryland has shown its strong support for remedying the impact the criminal legal system has on the ability of its citizens to escape poverty and lead productive lives. Reducing excessive waiting periods and significant eligibility restrictions supports proactive rehabilitation and will allow all Marylanders, including criminalized survivors, to escape the shadow of their criminal records. And for these reasons, the Human Trafficking Prevention Project supports Senate Bill 710 with sponsor amendments. We thank Senator Patterson for his leadership in bringing this bill and respectfully urge a favorable report. Thank you. Who would ever like to go next? Do you want to go? Go ahead.
Good afternoon, members of the committee. My name is Harold Coleman. I'm a lobbyist, and I'm in support of Bill 710. My journey started 33 years ago, and I had a bad criminal history. I ended up getting a sentence in 97. I served 7.5 years on a 13-year sentence. I was released on mandatory supervision parole in 2005. Once I was released, I got a job with the Maryland Transportation Authority here at the Bay Bridge, and I've been employed ever since then. My sentence expired in 2009. I have not been in any trouble since then, and under the new expungement bill, I have to serve 15 years. And I've been on the street since 2005. The sentence didn't end until 2009, so it was 15 years from 2009. So I won't be eligible to get the rest of my record cleared until 2024, October. And I'm currently still employed at the Bay Bridge for the state of Maryland, and you know, we need to come together and get everything good so we can get the community back in and people to get jobs. And I want to be the face for those people. You know, that's what it's all about. We all here together. We live in the best state, but the way things going in the city, it's tough. So we have to make a difference. And I'm in favor for the bill. Thank you for your time.
Good afternoon, members of the committee. My name is Elena McWilliams. I am the Policy and Research Coordinator at Out for Justice. I'm also a licensed psychotherapist with over 10 years of experience providing trauma treatment to people who are formerly incarcerated, as well as a researcher who's published multiple articles on criminal record discrimination. I'm here just to assert the point that this is not anecdotal evidence. This is not hearsay. This is not opinion versus another opinion. There are scientific articles with large-scale data that reinforce the fact that criminal record discrimination and the stigma caused by having a lasting criminal record counters all of our goals. So we might hope that employers will give people a chance even though they have a criminal record. These large-scale scientific audits show that they don't, unfortunately. We might hope that people with criminal records are able to connect to people in their communities without stigma, or people will understand, but we find that over and over again they experience rejection. These and many other forms of criminal record discrimination and stigma, statistically and in a wide scale across our country, cause major mental health concerns, and I encountered that over and over again as a therapist. And that's why I came back and did research, because I felt like I was up against a system that was churning out really severe mental health conditions. And unless we change the system that marks people for an inordinate amount of time, we are going to have a mental health crisis on our hands. And also, this type of criminal record discrimination caused by these inexpungible records actually reinforces recidivism rates. People who experience discrimination due to their criminal record are more likely to recidivate. So it's not serving any of us, and I urge support for Senate Bill 710.
Good afternoon. My name is Nicole Hansen. For the record, I am the Executive Director of Out for Justice, an advocacy arm that is led by formerly and currently incarcerated individuals who've committed their lives to, one, educating themselves on this process, and two, ensuring that we lead healthy lives that contribute back to society, similar to your constituent who may have done something that was on the other side of the law, but that constituent of yours is trying to move forward, trying to rebuild their life, and can't even get inside of their own child's school, right? So that's somewhat contributing to the delinquency of a minor, if you know, if you leave it up to me. But Maryland has drastically longer waiting periods for expungement than most other states in the nation, as we do on a lot of our policy. Many expungement waiting periods are far longer than the actual sentence. We have a history of doing that too. We're actually leading in that way. In an effort, this doubles, sometimes triples individuals' sentences to separation from society because they will experience ongoing criminal records. And I can just tell you for the last 40 seconds that I get calls day after day after day at my office in East Baltimore, where men and women are moving forward with their lives. Some men are driving trucks, getting their CDL licenses. Others are pursuing other occupational licensing. And the one thing they talk about is expungement. Why do I have to keep paying for the thing that I already went to jail for? I've already served my time on probation. And like Mary Denise, I say, go talk to your state elected officials, because clearly there's a disconnect between what is actually happening on the ground with your constituents and the laws in which you process and you pass. And so for those reasons, and thank you, Mr. Chair, if I could just finish my statement. For those reasons, Senator Watson, you have constituents in Prince George's County who are dying to connect with you and tell you how these laws are impacting them. Ms. Kiana Johnson is sending you emails on a regular basis. If any of you, I have members in every county that can bring the stories to you to tell you how these records and these waiting periods are impacting their lives for all the wrong reasons. And it's pushing them back to a life of crime. Thank you, Mr. Chair.
Excellent, thank you very much. Questions from the committee? Seeing none, thank you all very much. Thank you. All right, next we'll move on to, I think that concludes the testimony for the proponents of the bill. We'll now move to the opposition panel. Is Mr. Cox here?
Am I on my own?
I believe so. There you go.
Thank you. Chairman Smith, Vice Chair Waldstreicher is gone. Members of the committee, I'm John Cox. I'm Deputy State's Attorney in Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 710 and ask for an unfavorable report. I submitted written testimony, and most significant that I'd asked you to pay attention to the written testimony is the list that I prepared of both the misdemeanors and the felonies that would now be opened up to the potential for expungement that was attached. Sat at my kitchen table on Sunday and just started flipping through the book and finding some of those. Just throw out an example: possession of child pornography. 3.5 years after somebody gets convicted of possession of child pornography, or 3 years later, they can wipe that clean, and then caught maybe 6 months later, a judge would never know that 3 years ago they were also in possession of child pornography. The one that is totally lost in all of this is DUI. All misdemeanors can now be expunged. That would include DUI. So 3 years after the imposition of our conviction for a DUI, maybe somebody's 10th, they can wipe that clean. Ironically, they can't wipe clean their PBJ for the first one, but they can wipe clean all other DUIs. This is a great concern. I'm hoping it's a drafting error, but they also removed any waiting period for PBJs. So theoretically, you could get a PBJ today from a judge with 3 years probation, all kinds of conditions of probation. Tomorrow, file for an expungement, and it's gone. And so all those conditions of probation and everything along those lines are gone. They reduced the waiting period for STETs to 1 year. And when situations where STETs often having conditions on them for 3 years. So you've just obliterated the ability to have any sort of monitoring on somebody for a period of that time. The time calculation is just, it was slightly misrepresented. What it now would say is it's 3 years, as Senator Castley brought out, it's 3 years from the end of the sentence to, or the end of the sentence or 3 years, not from the conviction or from the end of the sentence. If I could just make one quick point, and that's in there, give you one example, and that is somebody gets convicted of stalking, second-degree assault, violation of protective order, gets 5 years in jail. They completely misbehave, don't get released for 5 years. The day they step out of jail under this, they can get all of that expunged. We ask for an unfavorable report.
Questions from the committee? Seeing none, thank you very, actually, we do have, Senator Watson has a question.
I have one question. And, yes, sir. You know, I struggle with this because when do you reach a point where somebody has done their time and they can restart their lives? And I think, you know, there's an exaggeration that you made. You said DUI could be their 10th. I'd submit if it was a 10th DUI, your license would be revoked. And so your perspective, You know, you list all of these pieces in here, and I read through everything. Probably a couple dozen in here. When do you think, in your heart of hearts, that this should be carried with you to the rest of your life? When should you be able to start your life after you've completed your debt to society? Everything that you were asked to do, you have done. When can a person be reasonably expected to be able to restart their life and have some semblance of a life, whatever life is left?
Well, thank you, Senator. First off, I've never seen somebody, a drunk driver, being stopped from driving if their license is revoked. But regardless, in addressing the issue, this legislature in 2016 through Justice Reinvestment went through that thought process in a painstaking way. They went through all of the crimes, those which can be considered for a time period in which somebody can have that particular conviction expunged. So that's the list that you see in 10-110. And that's the time frames that you see that this legislature gave very, very careful thought to in the time period that you all felt was the right time to wait for somebody to prove that they will not recidivate and that they were deserving of expungement. The legislature decided there were certain that would never be. And so you're right, there are some that would not be, and that's that list that I gave you of the misdemeanors and the felonies of those which should not be expunged, and somebody ought to know about for basically forever, absent somebody asking for a pardon or granting some other sort of remedy for which they could then get expungement.
Thank you.
Thank you.
And with that, that'll conclude the testimony for Senate Bill 710. We'll now move on to Senate Bill 672 with Senator Kramer. Senator Kramer, you're up.
And thank you for that, Mr. Chairman. Good afternoon to you, Mr. Chair, members of the Judicial Proceedings Committee. Ben Kramer here to introduce Senate Bill 672, which, colleagues, is a pretty straightforward bill. And it deals with how do we address particularly egregious cases of animal abuse and neglect that ultimately result in the death of the animal or the need for the animal to be euthanized per the direction of a licensed veterinarian in the state. Under current law, we have our aggravated cruelty to animals statute that requires, in prosecuting the case, that the thought of intent, the intent of the individual to when they're mutilating, torturing, cruelly killing an animal, etc., has to be proven. But what happens when someone is so reckless, so abusive, so neglectful that the animal, again, dies as a consequence of that abuse, that negligence, that egregious behavior that may have resulted in the animal starving to death, wasting away without food, water, being covered with parasites and infection to a degree that when the animal is discovered, it can't be saved. It has to be euthanized. Well, at the moment, in those rare but important situations, right now under abuse or negligence of an animal in the code, it's basically a slap on the wrist. So the bill before you seeks to provide greater opportunity to ensure that the courts have the ability to address these particularly egregious circumstances So it modifies our existing statute with regard to abuse and neglect to do the following. For a violation of this section that results in the death of an animal or the need to euthanize the animal based on recommendations of a licensed veterinarian, that the individual can be sentenced to imprisonment not exceeding 3 years or a fine not exceeding $5,000 or both. Very importantly, unlike the aggravated cruelty to animals section in our code, it does not change it to a felony. It remains a misdemeanor offense. But it does increase the penalty, and it increases the potential for imprisonment. The other thing that it very importantly does is that it gives the court the opportunity to do the following: prohibit the defendant from owning, possessing, or residing with an animal for a period of time determined by the court. Colleagues, our domestic animals, and very importantly, our companion animals, dogs and cats, are entirely dependent on us, on human beings, for their welfare, for their care, for their feeding, and as such, we as human beings have a significant responsibility to ensure that we don't abuse them and neglect them in return. So with that, Mr. Chair, members of the committee, there's an outstanding panel here that will be discussing the relevance and the need for passage of this legislation. And I'm very proud that my outstanding state's attorney, John McCarthy, from Montgomery County, is here to speak in support of the bill. And with that, thank you, Mr. Chair.
Excellent. Thank you, Senator Kramer. State's Attorney.
Thank you. Look, it's an honor to be here. And I think Senator Kramer deserves an awful lot of credit because I think he's the leader on a lot of these animal rights bills in the Senate. So it's an honor for me to stand with him on another bill to protect the animals that so many of us love. This bill really grew out of, we put together an educational program for animal rights groups in Montgomery County. We went out and we began to talk about some of the cases we were handling, and we were asked to kind of look at what we thought were some holes that existed in the law that might lend themselves to protecting the animals in the community that we love. And this bill is really the result of a collaboration between the senator, community members, and people that reached out to us in the community that talked to us about this hole that existed in the law. Look, I'm honored to be standing here with a lot of people from Montgomery County. I know there's multiple senators here, all of whom are great friends of mine from Montgomery County. But I stand here with a lot of people from Montgomery County, the people that run the Humane Society. But I stand here also on behalf of the State's Attorneys Association of Montgomery County, which supports the bill. The association supports the bill. And I'm also proud, you're going to hear from Carlotta Woodward. She runs my animal abuse unit. She's going to tell you a couple of stories. She'll give you some really practical stories that will make you understand why this bill is so vital. And Joyce King from Frederick County is going to be here, and she's going to tell you some stories about cases from Frederick County. And I think if you hear a couple of the examples, you'll understand we're really not changing the law except increasing that penalty in the area of negligence, abuse of an animal, where death occurs. What really aggravates animal abuse is when it's intentionally done, and that's the aggravating felony that the senator already talked about. And now we're really looking at the consequence of your abuse. And when your consequence of the abuse leads to the death of the animal, there should be a more appropriate penalty. That's really what this bill does. It's very simple. Thank you. Carla?
Good afternoon, Mr. Chairman and members of the committee. Again, I'm Carlotta Woodward. I'm an assistant state's attorney from Montgomery County. I head the juvenile division, but I also handle all of the animal cruelty prosecution in our office. I'd just like for you to imagine 66 dogs being housed in less than 1,000 square foot in a home, cages on top of each other. They're living in their own feces and urine that is causing skin irritations to the point that become infection. Imagine that these dogs, some of them, have masses that have been left untreated. Imagine that their eyes and ears are infected from the unsanitary conditions that they are currently housed in. Imagine one of those dogs lost his eye. Imagine one of the other dogs lost the entire eyesight from untreated glaucoma. Ultimately, as a result of these conditions, and I could go on, of how unsanitary and disgusting these conditions were, that these 66 dogs resided in, 3 of those dogs had to be euthanized as a result. I want you to imagine another animal who has flea anemia, goes to the vet, needs a blood transfusion, but there is not enough blood in that dog's body in order to get a sample to determine the blood type in order to get that transfusion. And imagine an animal having to be euthanized because it had flea anemia. And had that dog had simple trip to the vet and flea medication, that dog would have survived. There needs to be an enhanced penalty for dogs who die or who are euthanized as a result of the acts that are enumerated in 10604. I speak for the victims who have no voice, and we are asking for a favorable report on Senate Bill 672. Thank you.
Good afternoon, Chairman Smith, Chairman Wallstreicher, and members of the committee. My name is Patty Crankshaw-Quimby. I'm the Executive Director of Talbot Humane and the Chief Animal Control for Talbot County. And I'm here today as the President of Professional Animal Workers of Maryland. We're the state organization that is comprised of animal control agencies and humane societies, and we stand in support of SB 672. As we know, with many crimes, there's levels of seriousness. We're looking at animal cruelty and neglect. This is also the case. There are levels of cruelty and neglect that do not rise to that of aggravated cruelty, which carries a more significant penalty, yet the animal may die or require euthanasia. We believe there's a loophole in the current law when it comes to penalties. In the current law, the maximum penalty for death of an animal is the same as that of if an animal did not die, that did not rise to the level of felony cruelty. We know the link between animal cruelty and human violence is direct and proven. Excuse me. This update will allow Maryland judges to consider a more significant sentence and a longer ban on ownership for the most egregious offenders of Code 10604. For this, Professional Animal Workers of Maryland respectfully asks for a favorable report. Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Tom Koenig. I'm the Executive Director for the Office of Animal Services in Montgomery County. I've been a Director for Animal Services for a better part of 17 years, 7 of them with Montgomery County. And I can tell you that over that time, I have witnessed many violations of the provisions currently found in Section 10604, particularly those that are involving neglect and the care of animals or animals that are found in deplorable conditions. These conditions are so unhealthy and so unsafe. It's not even good for human beings, much less their animals. SB 672 strengthens the penalties when charging violations under this chapter where the conditions and treatment of the animals is so detrimental to an animal's well-being that it directly causes the death of or requires the euthanasia of one or more of the animals we found. There are a number of cases around the state where this has occurred, and looking at SB 672 to be the bridge to close the gap between the misdemeanor and the felonies as previously expressed during in the aggravated cruelties, and the current penalty and the time that they can't own an animal is just insufficient for those that we've seen the death of these animals. It's pretty horrific. We've identified at least 6 other states that, including Virginia and Washington, D.C., that provide higher level of penalties for these animals that die based on their care or the living conditions that they were found in, or at least subjected to. The key driver in this really is the death of an animal or cause for the death of that animal. And that's why we respectfully urge the committee to adopt a favorable point. And I missed it, but I want to thank Senator Kramer. We had a nice talk on the phone about how to move forward with this bill, and I want to thank his sponsorship.
All right, seeing no questions from the committee, thank you all very much. Actually, sorry, here we go. Senator West, go ahead. You've got a question.
Thank you, Mr. Chair. Actually, I do. The existing statute, which doesn't have the bolded language in it, provides that, I guess this is for the making of the amendment, that if a person, owner of animal, fails to provide the animal with nutritious food in a sufficient quantity, drink, proper space, proper shelter, proper protection, there's a misdemeanor, and the response and the answer is the penalty is imprisonment not exceeding 90 days for a fine exceeding $1,000 or both, right?
That is the current statute.
That's the current statute. The new statute says that a person is only going to sustain penalties of imprisonment not exceeding 90 days for a fine of $1,000 or both for a violation that doesn't result in the death of the animal.
So the current statute remains in place and intact, with the exception...
If the animal doesn't die.
If the animal does not die. So this bill reflects the circumstance where the abuse and neglect was so severe that the animal died as a consequence of that abuse and neglect.
All right, thank you. Thanks for the clarification.
Thank you.
Well, actually, it's a little bit deeper than that, because what it really comes down to is whether you're subject to 90 days and 1,000...
Senator, would you mind leaning in a little bit to the microphone? I'm sorry, I can't.
Whether, can you hear me now? Is it working?
Yeah, thank you.
Whether you're subject to 90 days and 1,000 or 3 years and 5,000 depends upon the recommendation of a licensed veterinarian.
No.
Well, yes, sir, it does. It's either animal died or it was euthanized based upon the recommendation. So if you got a veterinarian that's more aggressive in helping animals, I lucked out. 90 days and $1,000. If I have a veterinarian who's more prone to say, it's not worth it, euthanize, I just went from 90 days and 1,000 to 5 years in jail, or 3 years in jail and 5,000, right?
I would proffer to you that if the animal is so severely abused and neglected that we are now waiting on a veterinarian to make that determination that A, that's a significant issue, but B, I suspect that a licensed veterinarian in the state of Maryland is not going to be looking to go out of his or her way to euthanize an animal if there is an opportunity to save that animal. So, so yes, the additional penalty is a consequence of the need to address those circumstances when the animal is so severely abused or neglected that a licensed veterinarian in the state says, hey, we can't keep this animal alive.
Yeah, we're used to criminal statutes that says, you shot the guy and he died, you get this. You shot the guy and you're lucky he lived, you get that. We don't say, well, the hospital decided that it wasn't worth saving him. The hospital's going to try to save him with everything they got. It's a little bit different with animals, because you may have a veterinarian that says it's not worth the suffering, or it's not worth the cost, not worth whatever. It's just different. I just find it interesting because it's a new issue that we would face in saying in the criminal law, because now as a defense attorney, you would be saying you'd be in the position of trying to assert the incompetence of the veterinarian, or the lack of empathy or sympathy by the veterinarian for the animal that could have been saved versus not saved, that becomes the issue at trial. So it's interesting.
And
All right,
that
we'll take a
is,
look.
you're
Might I add some-
absolutely, go ahead.
Excuse
No,
me, I don't
please.
mean to interrupt. Let me just add something to this. The medical exam that occurs by the veterinarian in these cases, in every case, the cases that we handle, go through the veterinarian. He conducts an extensive forensics exam. And when he makes this determination, everything is documented. He's documenting the health, the well-being, and only makes that determination, which would have to be shown in court, if you're filing charges on this. He'd have to show this in court and be able to speak to the forensic reason why that animal had to be euthanized. So it's a little bit tougher level once you get into court and you have to prove that the animal had to be euthanized.
Thank you.
And I'll also, if I can, Senator, just add, this is hopefully a compromise between what exists in the two different areas of the law that currently address animal abuse and cruelty, and trying to find a very niche area for where it is when the animal dies. So that's the purpose.
Thank you, Mr. Chair. Senator Kramer, so if the licensed veterinarian determines that the life of an animal can be saved, and say it cost $2,500 to save the animal, right? Who pays for that cost? Because the way I read the bill is that the violator, would pay a fine not exceeding $1,000, but who would actually pay the cost to get the animal back to health?
Well, and very often that could be a humane society, it could be any of a myriad of volunteer groups that very often cover these expenses. And so it's not an issue of whether the veterinarian is making this decision based on cost. That is not part of what the bill is about. And in fact, in Montgomery County, our own animal welfare services could do that very thing.
Okay, thank you.
Thank you.
All right, seeing no further questions, thank you all very much.
Thank you, Mr. Chair. Thank you, committee. Appreciate it.
And we have two more panelists, so if Mr. Breckenridge and then Ms. King could come on up.
Mr. Chairman, members of the committee, good morning, or good afternoon. I'm Jack Breckenridge. Trying to rush the day, I guess. I'm the cruelty investigator for Montgomery County's Office of Animal Services, and I wanted to share just a couple cases with you where this law would enhance the penalty. So two are mine and one is from St. Mary's County. The first one from Montgomery County was a dog owner put her dog in a board and train situation with a boarding kennel in Baltimore County. The trainer brought the dog home to Montgomery County, where we proved through evidence the dog was wearing a GPS collar. He took it out when it was more than 100 degrees outside, worked it for way too long. He started texting with his boss and everything and showing the signs that the dog had heat stroke. He ignored it. The dog eventually died, and I had to tell the owner, hey, I can charge this guy with a 90-day misdemeanor, and I can stop him from having contact with pets for the length of probation for the district court. Another one was, guy took his leash-adverse dog into a groomer. The groomer was in a rush, rather the bather was in a rush, so she restrained the dog by the neck in a manner that it couldn't escape from the slip lead. She basically defeated the safety mechanisms. And the dog eventually choked itself to death just trying to get away from her by pulling it was tied to a grooming table. It was a larger dog, and it pulled the grooming table away, choking itself to death. And then the third case from St. Mary's County, they were responding to a complaint of a gravely underweight dog, and they found a dog that was basically a fur-covered skeleton. And the lady just wasn't feeding the dog. And that's one that went to a vet and was euthanized by the vet because the dog lacked the ability to have any positive physiological change from the treatment. And I thank you for your time, and I encourage you to adopt a favorable report.
Good afternoon, Vice Chair, committee members. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I am also here on behalf of the Maryland State's Attorneys Association to ask for a favorable report of SB 672. Upon review of our animal cruelty cases in Frederick County, I was shocked at the amount that we had of gross neglect that led to euthanasia. We had, I think, the majority of cases were large horses that were deprived of care, and it truly is a form of torture. And, you know, I echo the sentiments of my esteemed colleagues, but the one thing that I did want to highlight upon reviewing the case analysis of the ones in Frederick County is that there was a direct correlation between this type of conduct and the abuse and neglect in intimate partner violence as well as child abuse. So I did want to highlight that these are serious charges and deserve serious penalties. And with that, I would be open to any questions.
Senator Bailey.
Thank you. This question would be for the investigator.
Yes, sir.
You referenced an investigation where a person worked a dog and the dog died.
Yes.
What type of genetic testing was done on the deceased dog?
Genetic testing?
Yes.
None. So there was a necropsy conducted, and the blood work revealed that the dog died of dehydration.
So, and the reason I bring up genetic testing, that is because, you know, when you talk about working dogs, right now there's a very fatal disease, if you're familiar with energy-induced collapse, or EIC.
Yes.
Yeah, about 40% of all Labradors have it, right? If they work, and it doesn't matter whether it's 100 degrees or 50 degrees, right? Any threat that they have, they show signs of heat exhaustion, but there's nothing you can do for it, right? And it usually appears between 4 and 6 years old. And I just wanted to know that somebody that had bought a very high-dollar Labrador that had never gone through that testing, that all of a sudden was playing fetch with their dog in the yard, right? And then all of a sudden their dog dies and it's a warm day, right? That they're not facing some criminal implications because of the fact their dog died, when in fact, if there was genetic testing done on that dog,
Yeah.
right, it would show that EIC was in existence, the dog was a carrier, and that we weren't putting people in jail for something that they had no control over.
Correct, yes. So that case was charged as looking at the totality of the evidence that we had, which included the text messages and stuff from the trainer that showed that he waited almost 2 days before he even reached out to his boss, and basically waited until the dog was dead. So the dog had a very slow onset, and the necropsy, the autopsy for animals, didn't reveal any other underlying medical cause, but we didn't consider genetic testing of the dog.
So you don't do any genetic testing to see if that, especially as, you said you're familiar with it, especially as how prevalent that is in sporting dogs now?
I have not, so it's definitely something to consider.
Okay.
Thank you.
Senator Kessler, you had a question before. Okay, all right. Any other questions for this panel? All right, seeing no questions, that concludes the hearing on Senate Bill 672. We're going to now move slightly out of order from the original announcement and move to Senator Bailey with Senate Bill 673.
Thank you very much, Mr. Vice Chairman, members of the committee. Senator Bailey, District 29, St. Mary's in Calvert County, for the record. Today, I'm here to talk to you about a bill that would allow the Natural Resource Police Force to be governed and managed similarly to how other statewide police forces operate in Maryland. The concept for Senate Bill 673 was requested by members of the Natural Resource Police and was crafted to resolve an inconsistency in state law. To my knowledge, the Natural Resource Police is the last statewide law enforcement agency where the secretary of the department is not given the authority over the management of their police force. In 2020, this committee and the full General Assembly passed similar legislation to give the Secretary of General Services the same authority over their department's police force. This language is similar to the provision of law that governs the Maryland State Police. During the drafting of this bill, I was approached by members of the Black Officers Association of the Natural Resource Police who raised the issue that the NRP's promotional practices were not reflective of the demographics of the state. The figures that they were provided were absolutely appalling, and I understand and share their frustration, and I think you're going to hear from some of them today. I have been in communication with the BOA, as well as the State Law Enforcement Officers Labor Alliance, the Fraternal Orders of Police, and the Department of Natural Resources to offer amendments for this bill that in an effort to respond to concerns shared by all the stakeholders. It's one thing I think you'll find today is no matter which group they represent, they all have problems with the current process. I have requested that each group provide amendments to this committee that you will hear from today. The amendment that I'm submitting with this bill is a direct result of these communications with these groups and is intended to address these issues. It would require the Secretary to develop a hiring and promotional plan to ensure the Natural Resource Police reflects the demographics of the state to the extent possible by October 1st, and changes the effective date to July 1st to ensure that the department can address this as soon as possible. It is my belief that these added provisions and the bill as introduced hold the Secretary and the Superintendent accountable while giving the department the flexibility it needs to implement such a plan. This amendment also restores and conforms existing provisions regarding officers of the State Forest and Park Service which were inadvertently removed. Removes a provision of the bill requiring each appointee of the Natural Resource Police to be a state resident on the date of their appointment, and permits the Secretary to spend up to $100,000 to carry out requirements to advertise open positions to underrepresented communities. Having served for 30 years as a member of the Natural Resource Police, I know how important this agency is to our state, how critical it is that we address these issues in this committee as quickly as possible. I respectfully request a favorable report with the amendments on Senate Bill 673. You also have a reprint that was on your desks of the work that we had done with all the committees, and I think the other thing is the department submitted amendments today, but I think they were a little bit late, so I think you just got those electronically.
Got it, thank you. Before we take questions, let's go ahead and bring the rest of the panel up. Veronica Bruns, and Vincent Arillo.
Good afternoon, Vice Chair and Committee. I'm Veronica Bruns, a corporal with the Maryland Natural Resources Police and the treasurer of the State Law Enforcement Officers Labor Alliance, which is the exclusive representative for 8 state law enforcement agencies, including the Maryland Natural Resources Police. I am here to testify in support of Senate Bill 673 on behalf of SLEOLA. SLEOLA has the exclusive authority to bargain for pay, benefits, and working conditions of the Maryland Natural Resources Police. This includes the promotional process. During the negotiations of our current MOU, the promotional process was referred to the Labor Committee for disposition, or Labor Management Committee for disposition. This referral was the result of complaints from our represented membership and various employee groups. Their complaints, which I'm aware they are testifying to, include the promotional process was not fair or impartial to all protected classes. There was absolutely no transparency to the promotional process, and the promotional tests were not occurring on a regular basis. SLEOLA has continued to negotiate with management to make improvements of the promotional process. As a part of these negotiations, both NRP management and SLEOLA agreed we were hindered in creating a more fair, impartial, transparent, and unbiased promotional process by the provisions of State Personnel and Pensions Title VII that dictates the scope of the NRP promotional process Senate Bill 673 would allow for SLEOLA to directly negotiate the promotional process with the Secretary of the Department. This would allow for many of the complaints from the represented members and the employee groups to be resolved, and mirror other law enforcement agencies throughout the state as stated in my written testimony. Senate Bill 673 also provides language that the Secretary may allocate up to $100,000 a year for a consultant to be hired to target racial and ethnic communities or other individuals who are underrepresented in the agency. SLEOLA is in support of this as we recognize the agency has to increase demographics and members of various protected classes. And we would just ask favorable support for 673, please. And I'll stand for questions. Okay.
Good afternoon. My name is Vincent Arillo. I'm a police officer with the Maryland Natural Resource Police and an executive board member of the FOP 130 DNR Central Lodge. I'm speaking today in support and favor of SB 673. This bill will require the department to advertise open positions for citizens of Maryland of all communities, allowing for the creation of a more diverse police force representing the state of Maryland. Included in this bill are requirements for the Natural Resource Police promotional process. For a few years, the agency has gone without a promotional process. The process has not been fair and transparent for all members, including protected classes, and has been attempted to be negotiated by the State Law Enforcement Officers Labor Alliance, SLEOLA. This bill will allow for the direct negotiations between SLEOLA and the Secretary of DNR for a better process that is fair and unbiased for all members. SLEOLA has worked for years to negotiate a fair and transparent process for all eligible members of the agency, and this bill is crucial to creating opportunity for their continued efforts. The Maryland Natural Resource Police is the oldest law enforcement agency in Maryland, and I frequently meet Maryland citizens who are so appreciative and proud of the work we do. I speak on behalf of our lodge's members when I say we need this bill to create an opportunity for an even better agency for our members to work in, and one that all Maryland citizens will continue to appreciate and be proud of. As a representative of the Executive Board for FOP 130, I'd like to thank the sponsor of this bill and ask the committee for favorable support of this crucial legislation. Thank you.
Thank you. Questions for the sponsor or for the officers? Senator Sidnor.
Thank you. For the representative of the FOP,
Yes, sir.
I'm assuming that the members of the Black Officers Association are also a part of your membership, correct?
Correct.
So what are you all doing to ensure that their issues with this bill are being addressed?
So we have quarterly meetings, which all of our members are able to attend. We've brought up the promotional process and what we've attempted to negotiate and change and create better transparency, as I spoke earlier. And we've never had any opposition from any member that's come there to tell us they would like something different or additional things. I know our president, I'm not the president, but I know our president has reached out to the Black Officers Association. We've had initial negotiation meetings where we had a member of the Black Officers Association attend, but we haven't had any further consistent attendance from that group.
Because I can remember when I served on the executive board of the Legislative Black Caucus, and this may have been a number of years ago, these same issues that are being brought up in their testimony were brought up to us back then. So I know when the good senator, he and I had spoken about this legislation, it surprised me because for whatever reason, I had assumed that this issue was being or had been addressed. So when he had shared that he was attempting to address it and was talking about the concerns, again, I was grateful that someone was attempting to address it. But then when I looked at their testimony, and then as I'm listening to his testimony, I guess what I'm hearing is he would like to solve the issue, but he wants, but you all have not been able to meet some sort of an agreement, so we want to have you all come in support, and then anyone in opposition come and kind of let us know what the opposition is so we can fix something that seems to still be an issue.
Yes, sir. And that's what we want to do with this, is work together with all groups and the department. Every group that has representation for the department and what we're trying to negotiate. So any kind of teamwork that we can conduct to come to some sort of ground of agreeance would be what's preferred in the end.
Does your organization agree that there is a problem with promotions?
Oh, yes, sir. It's been an issue for a while. For years, we have attempted to negotiate this to create a better process.
If I may, because I do speak for the union, we have had numerous issues, and that's why we have agreed that there is a lot of discrimination and disparity throughout the entire agency. It's not just on one level. What this bill would do, however, is with the current falling underneath of Title VII of personnel and pensions, there's a lot of things that are hidden. There's almost an iron curtain. Being able to go directly with the department and the secretary to work on those things within the agency itself, it allows for more transparency. Currently, our promotional process is a banded system, which is then randomized. So you're not testing for where you're at. You would be testing to be put into a band and then randomized. So if you would score, say, we found somebody that scored 100, they could be randomized and placed at the 20th down on the list, even though somebody would have scored below them. Once that list is exhausted down to 5 people left on that list, that say the best category, they would then be randomized into the better category. So now we have somebody that could have scored 100 being randomized into a lower category. From there, they could end up on the final 5 again. When they get down to those final 5, they can be randomized into the qualified. So that's what personnel and pensions currently does. It's not a fair process. You could essentially walk in, put your name on the paper and walk out and get promoted above somebody who has studied and put the time and the experience in to get up 100% or to get close to 100 or the perfect score.
And to add, if I can add
Have you
on.
had an opportunity to read the Black Officers Association's their
I have
testimony?
not. I have had some brief conversations, but they have not been in-depth conversations, especially since the amendments, the rewrite has come out. We have not had any meetings with them to see where the issues were lying within that.
I mean, one of the things that they state is that, says this bill is an attempt to make the Maryland Natural Resources Police more like the Maryland State Police. It includes language into law modeled after the state police, which excludes the banding system and the rule of 5. For the and I'm assuming that's accurate, right?
Yeah, that's the banding system in the Rule of 5 is what I was just explaining. That's correct.
And this bill excludes that.
Yes, it does. So that way you would, what the goal and the intent from the labor side of things was that you would study and test like any other, if you take a test at school, if you take a test in the private sector or any other government sector, that you would rank, if you scored 90, you scored 90, and you would fit into that list as that percentage. So you're going to promote, now we're not being based off of demographics, but you would promote the top of that list to the most qualified position for the most qualified person. And that was what the intent of removing that banding system is, so that way you don't have the most qualified person and the person that put the work in putting at the very bottom of the list and possibly never being promoted. Now, to go in within that, at one point in time, prior to these negotiations, there was only a written exam. If you're familiar, many minorities are actually known to do less on the written portion of a test. So that's something that we worked on, that we did put it up to a three-pronged test, where it is a resume, a written and an oral portion of the test. But we're trying to work even harder so that way it's equal and fair for across many demographics, whether it be age, sexual orientation, ethnicity, racial, wherever anybody falls, we want it to be equal for anybody and everybody. We believe that if you put the work in, that's where you should go.
And that's the point of the three-pronged test, is to balance out different people's, doesn't matter your background or anything, where you would excel at in a portion of the test. However, when you have a test like the one we have, where they don't actually give you the score of how you do on portions of the test, and then you get randomized in the end of the test, how does that work for anyone? It doesn't look the greatest for a process to be fair and for people to understand how they placed where they placed.
In this particular test, has it been, I guess, adjudicated to ensure that it's not one of these discriminatory type tests?
The testing does come from a vendor. However, once the vendor produces the scores, it is handed over to our natural resources, human resources. Those are the ones that will put the names into a computer to be randomized. And that randomized list is then given to command staff to do the promotions. Prior to this year, nobody knew who fell where on the promotional test or the promotional list. And nobody knows where people were promoted from. Were they going straight down the list, or were they just picking and choosing who they wanted to promote, which would obviously be extremely biased and extremely partial.
And why, the question that I asked the gentleman from the FOP, I wanted to ask of you, I mean, why do you think that the hiring isn't reflective of the demographics? And what do you think is going on?
That one, I know this year that there was pressure to create a plan. A plan has been and is in the works currently. And with the newest recruitment process that is occurring right now, they are working at targeting and opening up for more demographics that are more minorities or protected classes. There's almost this iron curtain that has always been in the agency, and that's why we do want to move out from personnel and pensions. And I feel like that may have been something towards the hiring aspect as well, but I can't, as a corporal within the agency, I don't sit high enough in the rank structure to know exactly how that occurs.
It's hard to say that the agency's choice and direction of where they set up recruiting stations, that they're planning for that. As far as our positions, we can't say exactly how that's decided.
And the one last thing that I note within their testimony, I guess they they tell us that we shouldn't be using the state police as our industry standard, I guess, essentially because they don't have clean hands themselves. So, I mean, why do you all think that should be the standard?
It's something that our membership has come to us throughout the years. I've been on the agency for 10 years now. Since I came on the agency, people from the lowest level have requested that we do have more of a ranked system. Not necessarily the promotional process that the state police has to a T. This would allow us to negotiate our own process. It doesn't mean that we would be...
They're part of your membership as well, though, right?
That is correct. And they have been, when this started talking and coming to the works, they did have two of their representatives. It was their president, and I believe another board member at the time did come to the table.
Attended their initial meeting, too.
Attended the meetings. After that time, they kind of, for some reason, stopped showing up. Me and myself actually did reach out to the Black Officers Association on 3 separate accounts requesting that a member did come to us. We did, as the labor union, we did request that it was a member of labor because it doesn't make sense to have a member of management sit at the table on labor means. I can't have a member of management in negotiations with a member of management. It just doesn't work. Unfortunately, at that point, even though I had reached out 3 times, I was never met with them sending anybody. At that point, there was a lot of resistance, and I can't say why.
Thank you, Mr. Chair.
Thank you so much, Senator Bailey.
Senator, if I could just help you with a couple of the questions, and you brought out some great points, right, that really, show the fact, the lack of accountability that exists when we talk about the superintendent in the Natural Resource Police and the secretary, because they don't have the authority to make these decisions. The decisions, so these officers are controlled the same as civilians, not as police officers. And when we talk about the conservation job, there is a different recruiting tool. There are many different issues that need to be used, and the fact is, the reason that I put this together and utilized the state police was a direct result of what we saw last year. As you remember, there were complaints from the state police about issues with discrimination. And the first thing that we did when the legislature convened and started having those hearings, right, the first thing that happened, the superintendent was held directly accountable. They've got a new process, they've got a new plan, and it was addressed at their level. Now, the situation that I think that is paramount from talking to the superintendent of the state police and different officers that went through that, the issue is the way that I worked with the attorneys to try to craft this legislation was to set up guide rails to make them accountable so that they negotiate with all the parties associated. Whether they negotiate with the FOP, they negotiate with the Black Officers Association, they negotiate with SLEOLA, so that it is imperative that we make sure. Now, there are some things that existed prior to this. Banding existed, right? It was part of it. It was in the law. But the fact is, look at where we are. Look at the numbers that they have put together. It is atrocious, right? And that's why did I not include banding? Because I think that that's something that should be worked out, and it should be able, and that is from talking with other police agencies. That's something that they were able to address with their employees. You want people to have at least I would, want to have a role in crafting how that is going to happen and make sure that it works equally for every person and that there is no bias one way or the other. And I think it's imperative that that's my idea behind this. But clearly, that's why I've talked to so many of you about this bill. I give it to our committee, however we work it. That's what I'm really looking for, so that we're able to fix this, so that these officers, and you haven't heard from one of my classmates yet, but he's to come from when I went through the academy, but that is what is so important, so that we get this worked out.
Thank you, Senator. Now we're switching to the unfavorable. Michael Sewell.
Good afternoon. I'm retired Major Mike Sewell of the Maryland Natural Resource Police and past two-time president of the Natural Resource Police Black Officers Association. This afternoon, I'm requesting that you vote unfavorable for Senate Bill 673. Senate Bill 673 claims it will assist the Natural Resource Police with the ability to hire and promote, but in fact, the bill is trying to get around a mediation agreement in which the parties agreed to use the Rule of Five or State Personnel and Pension Section 7-208 and 209. The Rule of Five worked effectively for the 13 years I served as a major and sat on promotional boards. In 2016, when I retired, the Natural Resource Police decided to change the process and play word games to prevent the advancement of minorities. In the last promotional round of the 46 officers promoted by Natural Resource Police to corporals, sergeant, lieutenant, captain, and major, 0 were black. The bill states the Secretary may allocate no more than $100,000 each year for a consultant. The 30 years I spent employed with the Natural Resource Police taught me one thing for sure. When the Department of Natural Resources may do something for minorities, they choose not to. Last, Senate Bill 673 is in front of you as a law that gives the Natural Resource Police the same abilities to hire and promote personnel like the Maryland State Police under Public Safety Article 2-404. They are telling you this law will enhance the hiring and promotion of minorities. They do not tell you that the Maryland State Police does not reflect the demographics of the state of Maryland. Currently, the state demographics show 55% white, 29.9% black, 6.3% Asian, while the state police makeup is 83% white, 11.9% Black, and 1.2% Asian. Natural Resource Police is 83.7% white, 8.3% Black, and 1.1% Asian. So as you can see, the law does not change anything that will assist the Natural Resource Police to reflect the state demographics. This bill only allows the status quo to exist. Therefore, I request you vote unfavorably on this bill. Thank you for your time.
Thank you so much for your testimony. Question for the opponent of the bill, Senator Sidnor.
Thank you, Mr. Chair. So if I'm hearing you correct, well, let me start over. I believe what I heard Senator Bailey say was that the way that the current system is operating now is not working. And I'm assuming you would agree that it's not working.
Based on the last promotion, no, it's not.
But what you were saying was that the rule of 5, in the past, it had worked.
Correct.
But I guess for whatever reason, there may have been some things going on that were undermining how this rule was being implemented.
Yes. When I retired in 2016, there were some changes that were made as soon as I walked out the door. They started playing word games with the word random. For years, random means pretty much that the DBM would give you a list of people who came into the best band and the different ones. Within that band, you had the ability to select whoever based upon the needs of the department to best put them in the best light to be successful. And you had a lot of things you could consider, including gender and race and stuff like that. But the reality was to get you the best person to fill the mission of the agency. What they tried to do with the word random to try to make sure they weren't getting a few minorities at the top would say, well, no, we have to go in the order that the list came from DBM. So with no more a random list, now they're trying to say it was a numerical list that came straight through. The problem with that is when you take the test, it goes to DBM. The scores are not known. Only they know the scores. They just give you a list of who's in which bands. There are 3 bands. So the top band being the best, you would know that you're in the top band of best. You don't know what your score was. You're in the top band of better, you're in the top band of qualified. So once I left, however numerically this list came over to them, the department said, oh no, now we have to go strict by order of how the list came to them. So they try to say random meant numerical. I was like, no, it doesn't, but I was gone. I was retired. When I was there, I could argue those things. So those were the changes that were made. Additionally, since I've been told, is that there were negotiations going on with Sleola in the department that the BOA has vehemently opposed, saying that they were not illegal based upon the Sleola contract and based upon the state law. But the department did not want to hear it or entertain it, nor did they want to have a conversation. When it was brought up, when I was the president at that time, and brought it up to the department, they kept trying to say, no, this was not going on. They kept telling me that, no, we're not having the negotiations. I had a face-to-face meeting with the Sleola president at the time, Jimmy DeLay, and Jimmy DeLay told me that at his level, he was not trying to maneuver anything like that. He did offer us to meet with them, not as part of the management group or the work group, but as an informal work group. I took that back and said, yeah, we're willing to do that, but then we were told, well, we don't want nobody from management to be there in this informal group. And I understood the formal part as part of negotiation. It had to be a representative. So yes, processes were changed, procedures were changed, and as the results came out in the last hiring group, as we said, 46 people promoted, 0 were black.
Okay, so let me ask you this: from looking at, and this is your representative of the Black Officers Association, and it notes that there aren't any mandates in the bill, so you're looking for, I guess, some of the mays to be made into shall?
Well, excuse me. House Bill 605 is a bill that was put into place that has a mandate of shall, and put to the point that the department has to make a study, the department has to put a plan of action in place, and the department is required to make sure that 20% of the agency is reflective of the community to the point that by the year 2027, it shall reflect the demographics of the state. Okay?
You said House Bill?
House Bill 605, yes.
Okay. And I'm just trying to make certain that I understand what exactly you're looking for that would change your opposition to maybe a support. So you're looking for some stronger mandates and I guess you don't like having the state police as the standard, so I mean, what,
I mean, you're using the state police as a standard that does nothing different than what we're already doing. The only thing that this bill would do is give the secretary and the superintendent absolute power to justify what they've already been doing.
Gotcha.
I mean, I'm hearing that they're saying that they don't have any ability now, which is not accurate. I mean, I sit there as a major for 13 years. You know, there's a lot of power that the secretary and the superintendent have. There's a lot of accountability they have. They choose not to do it. You know, when I was there, yes, I pushed the envelope, and I kept pushing them. And there's time to time when DBM would try to give you guidance, you go have a conversation with them. You explain their position, they would explain their position, and then you came into a medium. But it was never to the point you were dictated to and that you couldn't do anything. The current leadership doesn't want to do it because it messes their goal. If they can simply say, I don't have to do it, I don't have to do it, so therefore the results are what you are. They were told 3 years before this list even came out that you keep going down this path, this is what you're going to get. Now, all of a sudden, when they go and make the promotions and everyone's saying, oh, my God, I can't believe this. What do you mean? You were told for years this was going to happen. You just didn't want to hear it and you didn't care.
look, thank you very much.
Thank you.
Thank you so much. Further questions? All right, seeing no questions, I believe that was the last witness for Senate Bill 673. That concludes the hearing for that bill. I'll go next. Senator Lee, if you want to. No, I think I'm going to go next, if that's okay, Senator Lee, and if you want to. Yeah, no, I apologize. We went a little bit out of order. And just for those watching at home, because members have bills in other committees, sometimes we need to move out of order, so.
So which, is this 877? Would you like to have your panelists come up?
Yes, please.
Okay.
Thank you, Madam Chair.
Not at
I'm
all.
so proud to present this bill. It deals with an issue that this committee has thought about before, but my hope is that this is the year that this bill can move forward. Senate Bill 877 deals with the cost of care of animals seized who are the victims of severe neglect or abuse. This panel passed a bill a number of years ago that allows for the cost of care to be covered in certain circumstances. Unfortunately, because we kind of just dipped our toe into it, the current law is not working well, and we need to return to it and pass something that is more robust. Senate Bill 877 allows our police agencies, county agencies, or humane societies to receive the cost of care where animals are seized because of severe abuse or neglect. It allows them to begin the process of petitioning for that cost of care earlier in the process than current law. It allows them to file that petition just after the animal is seized. The care of animals is incredibly expensive. It not only includes domesticated animals like dogs and cats, but also often includes farm animals like horses, where the cost of care is extreme. This cost should not be borne by taxpayers. This cost should instead be borne by the abusers. And Senate Bill 877 provides a structure by which that can happen. So, only 12 states have no law that allows for the cost of care to be covered, and Maryland is one of those 12 states because the cost under current law can only be recovered later, and even then, most judges aren't requiring it. So what this does is it fixes current law by creating a clear, consistent procedure to determine the status of animals when initially seized. It provides a legal process so that anyone who has had his or her animals lawfully seized due to cruelty may be required to pay for care while the criminal case is being prosecuted. It gives the owner the opportunity to challenge the legality of the animal's seizure and the reasonableness of the care requested in a court of law. And like I said, it relieves Maryland's counties and shelters, and by extension, our taxpayers, from incurring the cost of care for neglected and abused animals that are lawfully seized. So let me be clear. The bill does not require folks who are indigent in most circumstances to cover the cost of care. The bill also has a cap so that it's covering only reasonable costs, not like luxury spa, animal care. And so in that sense, it has guardrails already built into the law. You're going to hear some examples from some of our counties about the sheer magnitude of the costs that are imposed on them that should better be paid for by the owner of the animal. Let me be clear, at any point, the owner of the animal can give up the legal right to ownership, and that allows the cost of care to be done. In other words, they no longer have to cover the cost of care. And more importantly, in this case, it allows the animal to be rehomed and the cost of care to be borne by the new home. So at any point, the owner has that opportunity. And with that, I'll ask for a favorable report and turn it over to my panel. Thank you, Madam Chair.
Thank you. Any questions of the sponsor? Seeing none, let's go to the first witness.
Hello again, Patty Crankshaw Quimby, representing Professional Animal Workers of Maryland. I'm also a shelter director and the chief animal control officer, and I've been with my shelter for 23 years. I've seen a lot over these years, and this bill is something that's very needed. You've received my written testimony, and you'll hear from my colleagues, so I will keep this brief. Simply put, animals are property in Maryland. Excuse me. Unlike other items which are seized that can be put in a locker or a storage yard, animals need daily care. Our cases run from the single dog to the puppy mill case, to the dog fighting case, to hoarding cases. They may involve dozens or even hundreds of animals, and there's a cost involved with each. These cases often take months or even years to go to trial, too often leaving animals in limbo. Currently, there are 245 animals sitting in limbo in Maryland shelters waiting for adjudication or, or on appeal. The current process in Maryland does not account for this issue. Even when restitution is ordered at sentencing, all too often these fees are not paid, and the cost of care continues to land in the lap of our taxpayers, not the owner or custodian. Several agencies in our state will be sharing, either written or here today, cases that make it clear how this law, the lack of a law, has failed. We believe this bill provides protections for both owners of animals and the agencies by clarifying the process at every step. I also want to make this clear that this bill refers to cases where the violations of Maryland Annotated Code have been allegedly committed, not for those animals which may be running at large or impounded as stray, where at the local level these infractions have administrative remedies. Maryland is in the minority of states lacking a clear process to address the cost of care for seized animals during cruelty cases. We ask for a favorable report on 877.
Senator Lee, Vice Chair Waldstreicher. My name is Caroline Griffin. I am a Baltimore City resident in Senator Carter's district. I am the former chair of the Baltimore Animal Abuse Commission and currently chair the Maryland Spay-Neuter Board. I support Senate Bill 877. A decade ago, the ABA issued a resolution urging all states to pass some type of cost of care legislation, and this came in the aftermath of the Michael Vick prosecution, as well as the Missouri 500, which was a large-scale dogfighting conspiracy in the Midwest. These cases brought to light the substantial burdens on shelters during these large-scale seizures. And since the resolution was issued, most states have passed some kind of cost of care legislation. And this is a significant deficit in our Maryland statutes. The Animal League Defense Fund ranks Maryland 32nd in the nation, far below every adjacent state, including West Virginia, which is ranked as 20th. And if you look at the analysis for why we are ranked so low, the first critique is we have no provisions for pre-conviction forfeiture of animals. I would argue that there is nothing inequitable, unfair about Senator Wallstreicher's bill, and in fact, it's what our family law courts do every day. In a divorce case, when parents cannot agree, the court will order the non-custodial parent to pay pendente lite child support to the other parent, because parents are required to pay for their children's expenses, whether they live with them or not. This bill does exactly the same, but actually has more protections, because if the court gets it wrong, the owner gets their animal back, as well as their expenses. I submitted an op-ed to the Baltimore Sun on this issue, which they published last week. I've submitted that along with my written testimony that includes the ABA resolution and the ALDF rankings and analysis for Maryland. I urge a favorable report. Thank you.
Okay, thank you. The next panelist, and Senator Bailey will entertain your question after we have the last of this panel.
Good afternoon, Mr. Chairman, Ms. Chairman, sorry, and then the committee. I want to thank you for the opportunity to testify with this bill. I want to thank Senator Wallstreicher for his sponsorship and leadership in this matter. As Director of Animal Services in Montgomery County over the past 7 years, I've witnessed many cases of cruelty, abuse, and neglect requiring my office to see large numbers of animals and absorb them in our shelter facility. You heard about some of those cases on SB 0672. Many of these animals required extensive veterinary care and additional care just to address not only medical issues, but some unique and specific care needs that go beyond just normal care. From cases involving cockfighting, dogfighting, hoarding cases, or just animals in living conditions that aren't even fit for humans, much less the animals that they care for. These cases can take months to process through the courts, causing extended and expensive housing and care not typically planned for in the annual budgets for our animal shelters around the state. And in my position statement, I put a list of how long, 4 cases that shows the number of animals and how long that had to be held. I want to take a little bit different approach and to make sure that this bill, what this does, it creates a structure, as Senator Wallstreicher said, where you have to, the petitioners are not asking innocent owners to pay for their care. SB 877 requires seizing agencies or the petitioner to demonstrate to the court that the seizure of the animals were warranted and that the continued possession of those animals by the seizing agency is also warranted. So when you petition the court for this, you're showing your evidence. You're coming forth whatever level of evidence you need to demonstrate that that seizure was warranted. And I think it's a very important aspect. We have a neighboring state who does this, been doing this for years, and has been very successful with that regard. As such, to present that level of evidence necessary to meet these 2 conditions, and if demonstrated, this evidence should more than satisfy the court in determining whether the cost of care, including veterinary care, is appropriately assigned to those identified as owners. I respectfully urge that the committee adopt a favorable report.
All right, this is the end of the panel. Thanks. All right, Senator Bailey.
So my question would be for the last speaker. And my question is concerning this. You're talking about, well, first you talked about the fact that you seize animals, and I live in a pretty rural area, grew up on a farm where we had a lot of cattle right in our barn, and you said you take these to your actual animal shelter. If you take cows to animal shelter, you have animal shelters that can take care of cows in your country? Because we don't have that in mind.
No, we don't. That's a good question, though. Many times when we have large animal seizures, especially like cockfighting operations, but even with larger animals and livestock, we generally board them through another facility that has the space to care for them. So that's usually done through a contract with a farm or with like a boarding facility for horses. And we've got longstanding relationships with some of those people, so we're able to find that. Sometimes we seize on scene, and we basically have them hold the animals. And we'll take care of them, but they have to hold the animals, and they can't. They're given an order not to move them. So there's a couple different ways to do that.
Well, there is, but having grown up on one farm where we had beef cattle and our neighbors ran a full-service dairy, right? If there's a significant situation if you were to seize dairy cattle, right? They got to be milked every day. I have no idea how you would go about doing that, right?
And I haven't had to, and I don't want to, so I
Yeah, but
I get your
doesn't,
point.
but this gives you that authority to obviously do that without, and this is my further question, without any oversight of a court? Is that what you were just getting to?
Well, the point of it is that if you're going to petition for the cause, regardless of how you end up managing the care, but if you're going to petition for the cost, you're going to have all the evidence there to determine that, they're in violation of either the aggravated cruelties or 10-604. But you're going to have the evidence for that, and you're going to have to give that evidence at the hearing for when you petition for cause. So that's what I was addressing.
Yeah, just in addition to clarify, the bill in front of us does not change the law with regard to the seizure of the animals or the placements of the animals either with a third-party vendor or with a shelter. So the bill doesn't change the structure of the seizure. The bill only changes the structure of the cost being covered by the person who is the criminal or the alleged criminal who conducted the abuse or the severe neglect.
Thank you.
Thanks, Mr. Chair. Mr. Vice Chair Walter. I apologize if this was already addressed because I missed the beginning of the hearing, and I want to say hello to my constituent. Nice to have you here.
Senator.
Hope to have
She
you
gave
on
you
one
a
of my.
shout out earlier.
No, I was here.
Oh, okay.
Hope to have you on one of my bills too one day soon.
Thank you.
So I was just reading the opposition of the Maryland judiciary, and two of the things they stated. Did you address it? One, I kind of just on first blush tend to agree with, that it calls for seizure at the beginning of a hearing, not the commencement of a hearing. Is that something that you'd be inclined to work with?
I think that's something we can work out, yes.
And the other thing says that there's a line between criminal and civil that is a little blurry with the way this structure is. So I'm just pointing those things out. I don't know if you already addressed it, but they seem, their points, sometimes they're not reasonable, but these points seem relatively reasonable to me.
I agree, and we can address them, and we will as this bill moves forward. I would just say that for the purposes of the seized animals, under Maryland law, animals are property. And so you're seizing property. None of this affects the rights of the person who is alleged to have committed a crime or the high bar that is required to convict under our criminal statute.
Thank you, sir.
All right, seeing no further questions for the panel, thank you all very much.
Thank you.
Next, we'll have Ms. Radoff, Thomas Coing, Ms. Bevan Dangle.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the State Director for the Humane Society of the United States here in Maryland. Thank you to the Vice Chair for the introduction of this important legislation, and many thanks to Senator Reedy, who's carried this bill for many years, but when we lost him from your esteemed committee, he was gracious enough to share the bill with a committee member so that we could keep it live in front of you. I do want to just reiterate a few points of contention that have come up. I can't speak, any more eloquently than our shelter partners already have over the need for this legislation. But there's three primary reasons from the humane perspective for this bill. Seizures are often delayed or don't move forward at all because the seizing agency does not have capacity or does not have the resources to care for these animals. So despite the incredible progress this committee has made on many pieces of legislation, advancing strong cruelty laws and protections for our animals, this is the bill that makes all those laws happen. This is the bill that allows our seizing agencies to act on and keep these animals safe. This legislation also addresses a deep-seated lack of clarity that the court pointed out in a 2017 case, and you have this information in my written testimony. But the court said in 2017 that there's no clarity over what the ownership and possession rights of these animals are when they're seized because of confusion in the current law.
So we see different standards in every single county. We don't feel that's fair to animal seizing agencies or to owners, because frankly, there needs to be consistency in how this law is going to be interpreted. So one of the really important pieces here is just creating that clarity and that standard across all of our jurisdictions. We appreciate Senator Waldstreicher mentioning the guardrails in the bill to ensure that people who have restricted financial means, don't inadvertently lose pets simply because of their financial situation. And so we feel those guardrails, especially the aggressive cap on the costs, are a very strong protection. You'll hear some concerns about having livestock, and to Senator Bailey's point, I have about 11 geriatric sheep, and I can't imagine anyone trying to seize them, move them off-site, or care for them. And the livestock inclusion is important in here because livestock are incredibly expensive. $176,000 for 19 horses seized from a St. Mary's County farm just last year already, and those costs are increasing every day. So we do feel livestock is incredibly important inclusion in this bill. So thank you very much for your consideration.
Good afternoon, Chair Smith, Vice Chair and Sponsor Waldstreicher, members of the Judicial Proceedings Committee. My name is Lisa Radov. I'm the Chair and President of Maryland Votes for Animals, here in support of SB 877. I would also like to thank Senator Reedy, who for many years was a sponsor of this legislation, as well as a member of this committee, and for also so graciously passing it along to Vice Chair Waldstreicher. 38 states already have cost of care laws, including all of our neighboring states. That's Pennsylvania, Virginia, Delaware, and even West Virginia. This is not new legislation that Maryland would be going out on a limb with. It would simply put us in line with all of those other states as well as our neighbors. As you've heard from my colleagues and boots on the ground, people from agencies, this would be a bill that would help in terms of financial problems with these many agencies. In addition, this bill also allows for seized animals who often can be considered too much of a financial burden to be adopted into loving homes. These shelters and rescues often have these animals waiting around for years when they could otherwise be adopted into loving homes. How often do we get to pass legislation that is compassionate and fiscally responsible, where taxpayers would not have to pick up these expenses? This would establish a uniform system. All parties, including the accused, the animals, and all animal control agencies would be protected. I would like to thank Vice Chair Waldstreicher for his sponsorship of this compassionate legislation and urge a favorable report. Let's make this year the year. I know you guys are tired of hearing us talk about this bill. Thank you.
No, that's not this bill, that's the other bill.
Both bills. Pass both bills. 2 for 1.
Oh, yeah. Oh, questions from the committee? We'll get it right, we'll get it right. All right, thank you both very much. Thanks.
Thank you.
All right, is Thomas Coing here? No.
He already spoke.
Okay, got it. And Joseph Michael.
Hi.
Hey, how are you?
Great. Mr. Chairman, Mr. Vice Chairman, members of the committee, I'm Joe Michael. I'm the Deputy State's Attorney in Washington County. I've been a prosecutor 29 years. Off and on, I've handled large animal seizures. I'm here to testify in favor of this bill, but insist that it be amended. The problem, and I'll get straight to the point, the way that the bill works is if there's a seizure of animals, and I'm talking about livestock. I'm not talking about companion animals. I'm not talking about dogs. I'm not talking about cats. I'm a farmer. I'm a licensed stable owner here in Maryland from the Department of Agriculture. I'm talking about livestock. If there's a seizure of animals, there doesn't need to be a warrant in here. Frequently there is, but animals, livestock live in open fields. And as Senator Bailey knows, law enforcement has the rights to enter open fields and make a seizure in plain view. So there wouldn't have to be a warrant. So there's not even an ex parte proof at that point based on hearsay that would be in a warrant to support the seizure. Animals would be carted off, and basically the requirement is that the agency that seizes them tells the owner, you have the right to petition for them back. All I'm asking is the amendment should be that the petitioner should be the agency. Any other kind of forfeiture, that's how it works. And instead of taking them and then saying, well, you have the right to ask for them back and have a hearing, it should be the burden should be on the agency, and it should happen right away. And that would get rid of this limbo that we're talking about. I think the limbo should go as well. I can give you a list of questions that should be asked. They should be asked by a judge. If no one asks for the hearing, if the person who is neglected the animals doesn't ask for the hearing, then they're automatically forfeited. Now, these are the same people that might be, and this happens a lot in large animal forfeitures, mentally infirm, incompetent, not speak English, backwards, if you will, and miss the boat. If they don't ask within 10 days, their animals, which could be their livelihood, are gone. And I don't think it's too much to ask for a court to be involved every time. I would like to take any questions that you have on this issue. I would encourage you to support the bill and simply require the court to be involved in every case where there's a forfeiture of the animals. And if the defendant doesn't come, then they're in the same boat. That's all. Thank you.
Excellent. Thank you, Mr. Michael. I think we have one question from Senator Bailey.
Yes, sir.
I just wanted to make sure, you said you referenced your amendments, and I haven't had a chance here to look. Are your amendments included, actually, the way you'd like the bill addressed?
I have not, Senator Bailey, but I'm happy to send those to you. I have looked at it. The second part, 10.615.1, suggests a process where the agency would bring their evidence. I think I heard one of my colleagues make references to that burden on them. I'm just saying that instead of the defendant petitioning for them back and then the agency petitioning for the cost of care, that they just start that process. And I also think there should be a warrant required for the seizure of livestock, not just a vet saying so. But I will get those to you, if I may, Senator Bailey, and maybe the sponsor, I will copy the sponsor with that. I tried to get them in, but I missed it. I missed the deadline, and that's what I'm talking about here. I missed the deadline for this very testimony. Same thing. I don't want that to happen to a farmer who doesn't speak English, or someone who's in the hospital because of an accident. That's all.
Excellent. Well, Mr. Michael, congratulations on your appointment. When is your investiture?
My investiture is on Friday at 4 p.m. in Washington County. Thank you, Mr. Chairman. I appreciate it very much.
Congratulations.
Thank you so much.
All right.
Thank
Seeing
you.
no further questions, thank you very much.
Sure
Thanks.
thing.
All right, I think with that, that'll conclude the hearing for Senate Bill 877. Well, now, Senator Carter, are you ready to go? All right, excellent. Let's go to Senator Carter with Senate Bill 784.
Thank you, Mr. Chairman. I have a panel. I know that there was a competing House bill that may have called them away, but I heard they should be back. And so I want to loudly call my panelists, Shaquille Carbon from Communities United, Elizabeth Hilliard from the Office of the Public Defender, Thomas Hidgen, and Ronald Phillips, also with Communities United. If you're here in the hall, could you please approach the panel and take a seat?
Senator, I'll be testifying instead of Ms. Hilliard.
Okay, thank you. Yeah. Sit down. So, Mr. Chairman, this bill and members of the committee, I know the day is getting long. It should not be too long or too arduous to listen to. I would propose this is a common sense bill that moves us beyond 20th century thinking when it comes to narcotics in terms of treating it as a health issue rather than criminalizing drug use and addiction. Senate Bill 784 moves small quantities or user units of harmful controlled substances from a criminal offense to a civil offense. In so doing, we would transition Maryland from being a state that criminalizes addiction to one that, through treatment and assessment, remedies it. According to a report by the Sentencing Project, Maryland is one of only 12 states where over half of the prison population is black. This alarming reality is undergirded by incarcerating drug users who possess small quantities of drugs and are in active addiction. In 2019, over 4,810 Baltimoreans were in Maryland prisons, accounting for 1/3 of the state's prison population, 60% of whom were incarcerated for drug-related offenses. Drug sentencing is disproportionate and makes drug use a criminal issue for some, instead of acknowledging it as a public health issue, which it actually is. Senate Bill 784 humanizes drug users. It recognizes that drug use is a health matter and that it takes a public health approach to fight the ever-growing drug overdose epidemic. Since the 1980s, drug sentencing is hardened, yet drug use continues to rise, and its effects continue to have a palpable impact on our communities. Between 1980 and 1985, the first ever large representative survey of U.S. population was done to identify various mental illnesses, including addiction. It found that 6.1% of Americans could be diagnosed with a substance use disorder linked to illegal drugs. The second time such a survey was done, between 2000 and 2005, the rate was 10.3%. Our nation now sees over 100,000 fatal drug overdoses annually. Clearly, current drug policy is failing. Decades of data demonstrates that drug treatment works. Since decriminalization of drugs in Oregon, the number of people who sought treatment in that state increased in just that year since it passed. This is the outcome that Senate Bill 784 could make possible in Maryland. Instead of incarcerating drug users, we must support them on their pathway to recovery so that they might become healthy, productive citizens. And for those reasons, I would propose a favorable report. I'm sure that some of the witnesses that have on the ground and practical experiences will attest to some of this, but the bill lays out specifically amounts considered to be for personal use, and offers that there would be a progression of sanctions. So there would be a penalty for a first offense of a citation, there would be a penalty for a second offense of a citation, and the third offense would be yet another citation and fine, and a demand that one would see a court. I looked at the bill and the testimony, and I agree, and I've talked to some of the advocates about it being potentially problematic that the bill would require a drug treatment court as opposed to other district court. And then we've talked about changing that and saying that, you know, there's a preference for drug treatment court, but of course we can't mandate what court a person chooses to use. Everybody has an individual right to choose if they want drug treatment court or not. And so with that, I'm happy to, really, I'd rather refer you to the panel and then ask questions, answer questions as a group. Thank you.
All right, thank you, Senator Carter. And then I have, for your number 2 witness, is the Shaquille Carbon.
Can I stay right here?
Would you mind standing up at the, just so everyone can see you? Unless it, and if it's easier for you down there, you got to do it then. Just want to make sure everyone can see and hear your great testimony.
Oh, sorry. Good morning, or good afternoon. Sorry, I've been here since morning. JPR, Chair Smith. My name is Shaquille Carbon. I am the son of 2 drug users, which is why this bill is near and dear to my heart. Neither of my parents have ever did time for possession, but had they did time for possession, my life and the successes that I have today could have went totally different and not been the case. But I want to talk a little bit about some historical context here when it comes to drug policy in the United States. So about 107 years ago, the United States Congress passed what is called the Harrison Act, which taxed and regulated medical opiates and criminalized the sale and distribution of non-medical opiates. This will be the first major law in the United States criminalizing drug use. The reasoning and rationale that thrust our country into demeaning drug use was based in racial tropes and newly founded stereotypes that persist today. In the early 1900s, the typical opiate addict was a white housewife who bought her drugs ostensibly as medicine, and yet the media spotlight mainly fell on Black and Chinese men whose humanity was not seen on par with that of white men, which continues to undergird the reality of policy not seeing drug users today as human, but as only criminals. One person testified, most of the attacks upon white women of the South are the direct result of cocaine-crazed Negro brains. This was testimony in a congressional hearing aimed at drumming up support for the proposed Harrison Act, the then proposed Harrison Act. A New York Times article also claimed The use of coke is probably much more widely spread among Negroes than among whites. Heaven dust, they call it. Its use by Negro field hands in the South has spread with appalling swiftness and results. There is very little doubt that every Jew peddler in the South carries the stuff, although many states have lately made its sale a felony. In a 1905 Times story headline, Negro Cocaine Evil, quoted a Memphis judge who claimed that the evils attendant upon the use of the drug covered the whole catalog of crime. Michelle Alexander notes in the new Jim Crow, Mass Incarceration in the Age of Colorblindness, that biased enforcement of drug laws means that more black men are under criminal justice supervision today than were enslaved in the year 1850. One supporter of the Harrison Act testified, moving away from African-American degradation.
Could we just, if you could just succinctly, we usually give everyone 2 minutes and just out of.
Oh, sorry, didn't mean to
no
go
worries.
over. So I'll just conclude and say we urge a favorable report for this bill. This bill is about treatment and not incarceration. If anybody believes, the reason why I brought up the Harrison Act, and I'll say this and I'll close, 107 years we've criminalized drugs. Drug usage and the impact that it's had, primarily on communities of color, has only increased. So we have to move from treating what is a public health issue as a criminal issue and treat it as the public health issue that it is. Thank you.
Thank you very much. All right, next, whoever wants to go next.
We're really polite.
There you go.
Good afternoon, Sir Chair, Vice Chair, committee members. Ronald Phillips, representing Communities United. This will be a testimony of personal sort. I still somewhat have bitter feelings about being arrested with 3 bags of marijuana and having over $100 in my pocket and being charged with possession with intent to distribute. And so I feel like this de minimis bill will combat that, and also it would distinguish the drug user from the drug dealer and stop just lumping up citizens in one big drug lock 'em up situation. I favorably hope you vote favorably for the de minimis bill because it is sorely needed. And to echo the fact that my colleague says, 107 years of incarcerating drug use should be unacceptable when our neighbors are legalizing and criminalizing each and every year. And I'm talking about up north in Canada and some point south. Thank you for the testimony.
Oops. Stepped on your crackers. Hello, Mr. Chairman, Mr. Vice Chairman, members of the committee. First of all, I just had braces installed, so I'm still getting used to speaking with them. My name is Thomas Higdon. I'm a resident of Baltimore County, and I'm speaking here today as a person in recovery and as the chair of the Drug Policy Work Group for the People's Commission to Decriminalize Maryland and a member of the state organizing team for the Recovery Advocacy Project. I am myself a survivor of addiction and the war on drugs, which is ironic because I was once a vocal and enthusiastic supporter of drug prohibition policy. Then I developed in my mid-20s a drinking problem, which quickly escalated into other drugs and eventually full-blown crack cocaine addiction. My struggle with alcohol and crack lasted over 2 decades and took everything from me. I was a respected member of my community with a promising legal career, and then I was an outcast. I was unemployed, indeed unemployable, and living under a tent, under the JFX in Baltimore. I'm grateful to report that today my life is completely different. In recovery, I have a loving family, a good job, and I'm a valued member of my community. When I look back on my experience, however, while crack addiction was terrible, and let me tell you, it is as terrible as people make it out to be, what was worse was the policies in place that I had to deal with. I was arrested at least half a dozen times during my drug addiction, active addiction, and I can tell you that interaction with the criminal justice system made it harder
to enter and sustain recovery. The stigma of being labeled a criminal, the dehumanizing way that I was treated, the barriers to employment and housing that come along with criminal charges, and indeed the quality of care that I received from drug treatment programs that I was referred to through the criminal justice system. May I finish this paragraph? Thank you, Mr. Chairman. Many of my peers in recovery have similar stories, and yet there is this notion that perpetuates that somehow the only way for people to get better is to lock them up, is to force them into treatment. And yet we have evidence. I was actually reading a study right before coming in here that evaluated 400 different studies, so this was a meta-analysis, and concluded that the evidence does not, on the whole, suggest improved outcomes related to compulsory treatment. Indeed, indeed, some of this treatment is actually harmful, which was my experience. And that's why I took off the day from work, put on the monkey suit, and drove down from Baltimore to Annapolis to speak with you today. And I thank you for taking the time to hear what I had to say.
Well, I put on the monkey suit every day to drive down to Annapolis, so I thank you for the testimony. There you go.
But you're getting paid.
We're making it rain over here in the General Assembly, right? Yeah, that's right. Yeah.
Well, that's a tough act to follow, but good afternoon, members of the Judicial Proceedings Committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland. And I'm testifying today in support of SB 784. Substance abuse is a public health crisis, not a crime. Years of punishment have led to increased overdoses, especially during the pandemic. Incarceration has failed, and instead what we need is treatment instead of punishment. Treating substance abuse as a public health situation instead of using the criminal justice system. SB 784 is fiscally responsible. I know Senator Carter was talking about Oregon, but it is expensive to incarcerate here in Maryland. And California actually is a test case for this. In 2014, they decriminalized, their jail population decreased, and saved the state $308 million in that first year. Incarceration doesn't work as a deterrent, and instead what it does is, as my colleagues have said, it increases the stigma that prevents successful rehabilitation. So incarceration can actually interfere with things like jobs, with things like housing, with things like family and community, all important to make sure that rehabilitation is successful. And what happens is when you have somebody who is charged criminally with possession of a substance, they must choose between getting a ride to court or getting a ride to treatment, driving to court or going to their job, taking care of their kids or taking care of their responsibilities to the criminal justice system. And many treatment providers actually won't accept, for inpatient substance abuse treatment, they won't accept an individual that has an open warrant from the court. What SB 784 would do is it would ensure that we're not prolonging the failed war on drugs, and instead we're focusing on solutions that are sensible instead of incarcerable.
Thank you all very much. Questions from the committee? I just had a question for, well, go ahead. Senator Weiss, you go ahead.
Thank you, Mr. Chair. So I'm reading this bill, and for a couple of years, we've been trying to deal with marijuana and get out of the marijuana crisis and decriminalize marijuana, et cetera. But I come to the second page of this bill, and it goes on from the marijuana and covers cocaine, crack, heroin, methamphetamine. Is this the first step in an attempt to decriminalize all those drugs and make them legitimate to be used on the streets of our cities and sold, et cetera?
No.
What we said in the testimony, it's an attempt to decriminalize drug addiction and treat it as a public health matter as opposed to criminalize addiction and users. It's not meant to sanction it and say it's okay, which is why there's still fines and court action imposed under the bill.
It seems as if in this bill, the possession of cocaine and crack and heroin and methamphetamine are treated identically to the possession of marijuana. I'm quite comfortable with trying to deal with the marijuana situation. I'm far less comfortable decriminalizing cocaine and heroin and those sorts of things.
Well, I think we should keep this in context and keep it in the context of people who are using. Differently than marijuana, these drugs really wholly debilitate people's lives, as we heard my colleague to my left talk about how it destroyed his family structure and so on and so forth. So we're not attempting to make anything easier for dealers or peddlers, but just to say, if you are a person like you or I who is in active addiction, there is no utility to public safety to put you in the carceral system. In fact, and I'll say this in close, we wanted to have more people here testifying, but I heard a powerful story of a woman by the name of Mary who was addicted to heroin and had to go through heroin withdrawal in a jail cell. And one of the things that she said that really stuck out to me was that she woke up every day wishing that she would just die because the pain of going through heroin withdrawal in a jail cell was just too much to bear. And so what this bill was attempting to do was to say, hey, we can't arrest our way out of this issue, but if we have infrastructure developed to provide people treatment and services, then we have to do everything possible in order to do that.
But isn't the message of this bill, if it's passed, that if you live out in the suburbs, you can drive down to the city to one of the open-air drug markets and you can buy cocaine or heroin or methamphetamine or crack, and the worst that can happen to you is a $100 fine?
Well, Senator West, I should posit that you could do that now in an open-air drug market. But if you were caught in either case, in one case you go to jail, you go through a horrible withdrawal, possibly, and then you come back out and you become a repeat offender, you do the same thing again. This bill is pushing people towards treatment and services that ends that cycle. Any person who has been addicted to drugs, who's been to a jail cell, will tell you they got out of jail and they went back into the behaviors that led them there in the first place as a result of possession. We want that to stop and we want that to end. And the only way that we can do that is by using medical science and medical data which says that treatment works, incarceration doesn't, and not try to be tough on crime, but be smart on a public health issue.
Okay, well, a couple of years ago, we passed the Justice Reinvestment Act, which, in my understanding of it, it was to deal with exactly this situation. Someone who goes to jail because he or she, mostly he, has been using heroin or crack or the other serious drugs, and while in jail gets treatment to break them of their addiction. Mental health counseling is needed, vocational training is needed, and then gets out of jail long before the sentence would have normally run out in order to try to live a life free of addiction. So that was the whole purpose of justice reinvestment, as I recall it.
So I wonder, I know you asked the question, Sarah, because I'm not the senator, so I'll just ask rhetorically, what happens to that person who's addicted if that jail goes on a lockdown? Or what happens when we house and farm people into this space where COVID is still running rampant? It seems to me that jail, if we look at recidivism rates, when it comes to any crime in this country, jail is not the answer. Jail doesn't work. And so treatment does work, right? The data bears that. And so I appreciate the point that you're making, Senator West. I would just say in this issue, we have to stop thinking about jail as a hub to help people, because jail, in fact, actually harms people, harms families. And if you've never been to jail, you probably don't know that. But as a person who works with people who have been to jail and family members who've been to jail, I can assure you that it's never the answer.
Okay. And if I can add just some technical additions.
Sure, yeah.
To add on to what Mr. Carver said, the Justice Reinvestment Act was mostly focused on people serving lengthy prison sentences. The charges that we're talking about here in this bill are the charges for which somebody is going to jail overnight for a few days, for 30 days. And so you don't have a lengthy treatment program at most of the local jails. Some of them do have some substance abuse treatment, but like you said, most of those have been interrupted because of COVID. And so we're talking about people who are being incarcerated for a day, 2 days, 30 days. and then they're released back to the community with fewer supports than they had prior to their incarceration. The Justice Reinvestment Act was focused on the people who are serving lengthy sentences, mandatory minimums for drug trafficking
All
charges.
right, well, let's talk about that for a minute. If you're in jail, then, and you're being given mental health treatment and treatment to break you of your drug habit, your body is physically present in a situation where you can't refuse it because that's being provided to you. But under this bill, if you're not going to jail, what forces someone who got a $100 fine from continuing to go to treatment as opposed to going back to their houses in the suburbs, and then when they want to shoot up again, going downtown to buy a little more crack cocaine?
I'll allow my colleagues to answer the question about the effectiveness of treatment when it's forced upon somebody in a carceral setting. But what I can answer, though, is that there's a disparity across the state about what treatment is available at local detention facilities. In fact, I just spoke to a client this morning who told me that he had requested mental health assistance multiple times, every time there was a shift change, and never actually got that mental health assistance.
But again, once you paid under this bill, once you paid your $100 fine, and you've been assigned to one of these programs, what is there that makes you go to the program?
And that's where I will defer to my colleagues as to answering the effectiveness of treatment.
So I would say that if there are plenty of consequences, natural consequences to drug use, if you take the criminal justice system out of it, there's still plenty of things that will drive a person to seek treatment and recovery. This bill will not prevent somebody from losing their family, from losing their job, from losing their home, from taking their own life. And these are all things, I don't know how many times I was hospitalized because I was suicidal because of my addiction. So there's plenty of horrible things that happen to people in addiction that lead them to treatment and recovery. But somehow we've developed this notion that the only way to get people help is to so-called force them. And it doesn't work. I had the criminal justice system try to force me to get sober many, many times, and it didn't work. In fact, I did not enter recovery until years after my last involvement with the criminal justice system. In terms of people driving in from the suburbs into the city, that's going to happen no matter what. But I will say that it doesn't happen nearly as often as people think because drugs are being sold in the suburbs. We don't talk about that, but drugs are being sold in the suburbs. I grew up in the suburbs, and I purchased my first drugs in the suburbs from somebody that looked like me.
Understood. No, I want to just, look, I guess my question would be, and you're going to have an opportunity to vote on 8 507 beds and a bill that talks about absconding and that not being a technical violation, back to your JRA points.
Right.
Forcing the issue for treatment. I guess my question would be, instead of decriminalizing dangerous substances, why not focus more on the 8 507 beds, which are a diversionary tactic? It's not, it's not a punitive thing. So why not focus on beefing up treatment beds, access to treatment, and then making sure that people actually engage? Because that 8 507 program, I don't know when you were going through the system, but, JRA greatly increased access. And then we want to make sure that folks actually avail themselves of that option. So I wonder, as a philosophical matter, why not focus on treatment beds and enhancing resources there rather than, decriminalizing cocaine? And I wonder, and to that point, where did you come up with the system of, I don't even know what 40 user units of LSD and methadone and 40 tablets of oxycodone and 1 gram of heroin. I don't know what that looks like, but where did that schedule come from? How did you go about creating that? What is that based off of?
Well, let me elaborate. Those are the standards that has been studied, and those are just the minimal of the drug that is being decriminalized. Not saying decriminalize drugs as whole, but just the small user portion.
Numbers came from the Oregon legislation that passed, and experts in the field consider that to be a standard amount, like a maximum amount of personal use.
It was studied by the National Drug Policy Alliance. That's where those numbers came from, looking at when users, not dealers, but when
Yeah.
users are buying, and let's bear in mind, sometimes users buy because they're partners, sometimes users buy in groups, or they buy for groups. What is the average across the board people are buying when they're buying for partners or groups? But I did want to really quickly address something. So after Measure 110 passed in Oregon, in 1 year, over 16,000 people have sought treatment. And some of that is undergirded by people who, as a result of the policy change in Oregon, sought treatment on their own. So this whole idea that, what Senator West brought up, I don't think we necessarily have to worry about it.
So 40 tablets of Oxy is like a personal use amount?
So,
But like, I know the price, but like, that's a lot of Oxy. Or like, I mean, and like, what is 40 units of methadone? What does that even look like?
But the specific
Like, that seems like
question-
a lot to me.
The specific question about Oxy, I can't answer.
Or 40
He's asking about
user
Oxy.
units of LSD?
40 units
Are we
of
talking about
methadone is
40
small.
tabs of like
Here's what I can tell you, and I appreciate the question,
Yeah.
Senator Smith. I'm a little hesitant to admit this in front of this panel, but it is the truth. Being close and coming up in a family where people sold drugs, I can tell you with absolute certainty that these are definitely 100% in line with what people who are users buy. And bear in mind, I do want to stress, when we think about users, people who are in active addiction a lot of times aren't just buying for themselves, but they could be buying for themselves in a partner. They could be buying for themselves in a group of people. These are not really consistent with what drug dealers would have in a stash or what drug dealers would typically have in a car.
No, I guess because first we started on the personal use amount, now you're talking about for a partner as well. But
Well,
I guess
and
as a philosophical thing, I guess what I'm saying, I think I'm with you on this. I mean, I'm 100% with you on that. I guess my point is, I think we should probably focus more on treatment and diversion as opposed to hanging someone up with a lengthy sentence or giving folks options to seek treatment, get that treatment, and then and without hanging them up or jamming them up with a record that's not expungible at the end of the day. But go ahead.
Have better answers than I do, but, so I think the purpose of this is also to deal with the front end, to keep them out of the incarceration, and 8507 is a motion that's filed, but that's already after they've gone through the process and been in jail, and that's a way to get out, to get treatment, but it's not at the front end, and I think that's what this is seeking to address.
Mr. Chairman, if I could, two things. One, just to address the personal use amounts. We were talking about this out in the hallway beforehand, and the best analogy that I can use is, how many of you drink alcohol? Yeah, and no judgment. I choose not to now because it led to crack cocaine. But most people who purchase alcohol purchase at the time that they purchase it. When you go to the liquor store, you purchase more than you are going to consume in that one sitting. You're purchasing enough for your dinner party or for the weekend, or maybe you are going to drink it all that night. But you purchase enough so that you don't have to go back to the liquor store that weekend. And that's what a lot of drug users do. They go to their dealer and they purchase enough to get them and their loved ones through the weekend or through that particular period of use. And the amounts in the bill are based on surveys of drug users done by the Drug Policy Alliance as to, okay, well, what do you do when you purchase drugs? So that's what that's based on. The other piece that I just want to emphasize is I want to say I am not, crack nearly destroyed my life. I do not want to encourage people using crack. But what I do want to do is to keep people who are using crack out of the criminal justice system if we can. And I think that's what this bill does. I think it actually, it walks a fine line because it's not removing the criminal justice system from the situation. We still have people who are interacting with law enforcement officers. They're getting a citation. They are getting I can't use that language. They are getting the stuff scared out of them because of this interaction. They're probably losing the drugs that they had with them. And this can happen a couple of times. And you're going to have people that's going to be what it took to get them to seek help for themselves. And so by having sort of 3 of those interactions before the criminal justice system comes in really strikes a balance, I think, for keeping people out of the criminal justice system, but also leaving this role for it.
I can also add, I don't know, were you going to say something?
Yeah, I wanted to also add though, it also keeps, the police officers for being overworked also.
What I was going to respond to, Senator Smith, was specifically your question about 8507 beds and why that's not the focus. And the answer to that is that they're not mutually exclusive. 8507 beds obviously need to be increased. We need to increase the, services that are available in the community. But those are addressing a different population than what this bill would address. This bill is addressing people who are arrested and charged for mere possession of drugs. 8507 beds are generally used for people who are serving lengthy prison sentences that come from crimes that were committed to support their addiction. And so both are needed and both should be increased, and we should focus on both ends. The front end of the system and the back end of the system. The people who are already in the criminal justice system serving lengthy prison sentences, increasing the beds that are available for substance abuse treatment, but also making sure that we don't push more people into the system, and that's what this would stop.
No, this is good. This is very instructive. Thank you all very much. Mr. Carbon, go ahead. Last word. Please be
Okay.
brief. There you go.
Thank you for your questions, Chairman Smith. I feel like this is really great practice for Shark Tank. No one has asked this question, and so I just want to put it out there because I think it's important. So in Oregon, and the only reason I bring up Oregon is because it's the only reference we have in the United States. Drug arrests have decreased by 60% in the 1 year since Measure 110 passed, and in this place, drug arrests decreased by 60%, and treatment of people in the state has drastically increased. And so I just want to keep that in people's minds as we talk about this legislation.
No, this is really good. I really appreciate the exchange. Thank you all for hanging in there all day with us. I really appreciate this. Thank you. Excellent. All right. Now we'll have Douglas Fuller, Rhonda Elsley, as Mikal Gross here. Oh, that's right. Got it. And Don Davis. We have Don Davis. Yes, if I called your name, come on up and.
There are a couple of people whose names you didn't call who are here.
Okay.
Don Davis?
Yeah, I just called Don Davis. Okay. Come on up, sir. Whenever you're ready. Whoever's ready to go first.
Chair Smith, other chairs, how y'all doing? My name is Kywan Jackson. I'm a youth organizer with Community United, and I'm here in favor. Based on what the panel said, this thing is to stop the embarrassment and the stuff that makes people want to use drugs. The criminalist bill helps people know that they have a safety net, have a thing of support. When you're using or when you come from a place where you are addicted, it's shameful. It breaks your pride. It breaks your will to live. And this also shows people that they're not less than. When you're addicted, you feel like you're less than. People talk about you, say that you're not human. They look at you like you're a criminal or something like that. So what we're trying to do here is trying to show people that this is not your fault. Anybody at any time could become addicted to any substance because everything has addictive quality to it. We're just trying to figure out and have a nice place for people to, if they're going to use safely, but also have a safety net and a place to go to realize that there are a support group and help people, because it's been shown when people are using alone, it affects overdose more. People have to share needles that also spreads HIV and stuff like that. And being a brother and a nephew of people who use drugs, seeing people ripped from their homes, wanting to go through all this pain and stuff of getting over addiction by themselves, it's just inhumane. And how can you tell somebody not to be like an animal if you lock them in a cage? Thank you.
Hello, Senators. My name is Charmaine Jackson, and I'm speaking for the addicts, the recovery people. I'm speaking to let everyone in here know jail time does not equal recovery. Addiction, that is a disease. It will kill you, it will hurt you. You lock that person up without getting any kind of treatment whatsoever. They are doomed to repeat the cycle. I know because I'm living proof. I was born and raised in the city. I had to leave it to get help. Why? Because they said single mothers like myself with disabled children belong in jail because, yeah, I'm an addict, recovery addict, thanks to Philadelphia. Not where I live, not where I was born and raised. They wanted to throw me in the jail. Today, I can actually safely tell you, I had to come from Philadelphia back to Baltimore. Because somewhere along the line, something's broke here. If you really think that it's okay to throw people in jail, no, that's not right. You need recovery. Profit, non-profit, you need recovery. That's what works. Therefore, you can have people come back and educate you guys, the ones that don't know about addicts or drugs. We can actually show you how you can help other people. You reach one, you teach one, you reach one. That's how it works. Thank you.
Hi, my name is Rhonda Elsie. I'm with Communities United. The committee I'm here to speak to today in favor of Senate Bill 784. And I'd like to talk a little bit about my story. I've not used a chemical illegally in 38 years. But that's because when I got clean, I went to get services for other things that happened to me. And since then, I've been offering my services. I was a part of a program called Tamar's Children. I helped start that program. Some of you may have heard about it. It was for pregnant women in jail. It was one of the best programs that I've ever seen. And because of politics and all that, the program ended. It actually helped me to learn more about myself and how to also offer to other people that information. I believe what's happening now in the some of the programs is they don't get enough to help people heal through all that they need to heal through. Because most people, very few people just drink or drug just because. Something happens, and then that is what helps them cope with the thing that's going on. Yeah, kind of an escape, but not really an escape. It's the cushion so that I don't kill myself or someone else. And until the other programs, I understand the methadone and all that, but the using is a symptom of what's going on. And so my hope is that you'll understand that and help push forth the money that's needed for the services and not just for the methadone. Thanks for allowing me to talk.
Is this working? Good afternoon, everyone. My name is Donald Davis, and I am an ex-addict myself. The bill that I'm supporting, and hopefully y'all will, is for a couple of purposes. In my years of on drugs, I've gotten caught with just two crack valves that I wanted to use just for the weekend. I was not an everyday, I was not out there. 2 crack valves can put you in on a Friday, can leave you in jail coming out on a Monday. You've been fingerprinted, and that goes on your background. And then you try to look for a job, and you wouldn't believe when the employer, some employers don't exactly check that job right away, because I've gotten on a job, and after the 3 days, I think they say 72 hours, but a week later, the employer comes to me with the list of charges. And they're all just because, actually, one time I got caught, because when you get caught, they take the drugs from you. So I came out, and I still wanted to do it. I couldn't go to work that Monday, and got caught again, and by the same officer. And and went through it again, but it wasn't a longer process. But for 2 to 3 pills or 4 or 5, I cannot see why these kids, or even myself, would have to go through that. It's hard to get expungements, sometimes the placements for people that's on the waiting list to get in. And when we have this addiction, we're just out for the drug to calm us down, to keep us healed. That sickness, that heroin is a, wow. That story that they told you about Mary in the jail, I never went through that, and I'm thankful of that. But I only can imagine, because I have went through the withdrawal, but I was not locked up. I only can imagine. So I just hope that y'all support this bill. It's not for 20 and 30, it's just for the user. It's not to help the dealer. It's to try to help the individual until they can actually find their way through, like myself, like Mr. Tom that was here, and all these other people here. We can do it. We just need the help. Thank y'all.
Questions from the committee? All right, seeing none, thank you all very much. This has been very helpful. Thank you. Thanks for spending the time with us, coming down here. All right. I called Douglas Fuller. Is Douglas Fuller here? No? Okay, got it. Am I missing anyone that would like to testify favorably? Did I miss anyone? Okay, so then we'll switch over to the opposition panel, and we have Mr. Cox.
I'm on my own again. I need to thank Mr. Kroll for calling and saying, as long as you're down there on the expungement bill, you mind talking about this one too. But I'm John Cox, Deputy State's Attorney for Baltimore County. On behalf of the Maryland State's Attorneys Association, Chair Smith, thank you, and members of the committee. The MSAA is opposed to this legislation. I have to confess that I've never used, bought, or sold any of these substances, nor have I prosecuted crimes of this nature, just about everything else in the office. So I apologize if I speak from some ignorance at some point. But just to address a couple of points, Senator Smith, I asked this morning, there's Senator Smith. I asked this morning as to the amounts and found some interesting information concerning, like say for example, the LSD apparently, the street value of that's in this list is $400. The street value of the oxycodone, if it's 30 milligram tablets, is $1,200. And yet some of the others are much smaller. The meth, I think, is about $80 for what's there. So it's quite variant. But the bottom line is what we wanted to get to, and Senator West, I think it kind of addresses one of the things that you mentioned. This is basically the equivalent of a traffic ticket. You don't even have to go to court. If we're somehow able to keep track of it, for the first 2 times that you get your traffic ticket, you just pay it. So there's no program anybody could put you into even if they wanted to through that. This is a circumstance, my wife happened to have started the juvenile drug court in Baltimore County and ran it for an appreciable period of time. I sat in there every once in a while and saw how many young men or women were thanking her for everything that she did. That was through the equivalent of the criminal justice system. The same is true of all the drug courts. I sat in the Anne Arundel County Circuit Court drug court recently and watched how many people were thanking Judge McCormick for what she had done. That was through the criminal justice system. There are benefits to utilizing this in order to get the treatment if that's what is needed, and we'd ask for an unfavorable report.
All right, thank you very much. Questions from the committee? Seeing none, thank you very much. And with that, that'll conclude the hearing for Senate Bill 784. Thank you, Senator Carter. Now we'll switch to our final 2 bills of the day. Senator Lee, which bill would you like to take first, 767 or 768? All right, so next up we have Senator Lee with Senate Bill 767.
I just want to get my panels here. First, SB 767. Okay. Everybody here? Okay. Yay, dream team. Okay. Thank you, Mr. Chairman. This is the first of my human trafficking-related bills heard today, and it's just a simple bill consisting of technical fixes and clarification. I've introduced this bill at the request of the advocates who represent survivors of human trafficking. The bill reduces the time from 60 days to 30 days necessary for notice and service before a court grants a vacatur. Next, this bill clarifies Section 8-302G1 with clarifying language about steps the court is to take after granting a vacatur. The court is to remove the underlying charges relating to the qualifying offense. Also included is a requirement that the court is to notify the movant so that they may file for expungement on the vacated conviction. Of course, if you'll look in your file, the judiciary has opposed this bill in part due to the reduction of the time required for the notice and service from 60 days to 30 days, as they believe this is not enough time. However, the state's attorneys and practitioners who are here today doing the everyday work have agreed that 30 days is ample time to provide notice and service, and it allows survivors a more speedier process so they are able to heal and explore life after trafficking. With me are several advocates who do the work every day and have the expertise and to advise on these simple technical fixes. For these reasons, I ask my colleagues to move favorable on this bill. We have panelists. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law. I am here in support of SB 767 with sponsor amendments. As this committee is well aware, survivors of trafficking are commonly arrested and charged for crimes that they are forced to engage in by their traffickers. Maryland responded to this injustice in 2011, enacting the second trafficking-specific criminal record relief law in the country that was actually sponsored by Vice Chair Waldstreicher. In 2020, this committee passed a much-needed revision to the law called the True Freedom Act, which expanded the list of eligible convictions and eliminated various procedural hurdles. However, implementation of this expansion has not been without its challenges, particularly around privacy protections for survivors and how to dispose of convictions that are vacated without a hearing. This lack of consistency and clarity has created confusion for the court as well as for the survivors themselves. And so in an attempt to remedy this, SB 767 would require vacatur petitions to be filed under seal at the request of the survivor or the state, and that any hearing on the matter be closed to the public, again, at the request of the survivor and the state. For motions that are granted without a hearing, SB 767 would require the court to dismiss the underlying charge. And finally, it would require that the court alert the survivor of the right to expunge the resulting non-conviction, an often forgotten part of the process, without which your intent in passing the True Freedom Act will not be accomplished. Through passage of the True Freedom Act in 2020, the committee has shown its strong support for remedying the injustice faced by criminalized survivors of human trafficking, further refining Maryland's vacatur law to protect survivor confidentiality and to make the process less onerous for both survivors and the court is an example of this commitment. And for these reasons, the Human Trafficking Prevention Project at the University of Baltimore School of Law supports SB 767 with sponsor amendments. We thank Senator Lee for her continued advocacy on this, and we respectfully urge a favorable report. Thank you.
Good afternoon, Chair Smith, distinguished members of the committee. Thank you so much for having me today. My name is Heather Hyman, and I'm an attorney with Maryland Volunteer Lawyer Service, where I manage the pro bono arm of the Human Trafficking Prevention Project. I connect survivors of human trafficking with free civil legal services through MVLS's statewide pro bono program, and I directly represent as well as mentor volunteer attorneys who assist survivors who are petitioning to vacate their past convictions. I'm here today in support of SB 767 with sponsor amendments. Petitioning for vacatur is a heavily lawyered process, and vacatur motions are often a matter of first impression for courts around the state. This bill provides needed guidance on motions decided without a hearing, which may be requested by the petitioner when the state's attorney's office supports their request for relief, and is a key provision to help prevent re-traumatization of survivors. The bill also contains provisions to streamline the vacatur process and safeguard privacy for survivors. These fixes are going to benefit the judiciary by clarifying procedure and expediting review, and they're also going to help attorneys who are providing representation in these challenging cases, particularly as many motions are handled by volunteer lawyers who may not be as familiar with the process as certain other advocates. Vacature is a critical remedy for criminalized survivors, and thanks to the recent passage of the True Freedom Act in 2020 by this body, it's a remedy that more trafficking survivors in Maryland can and will access in the future. So we need to make sure that it's working. We have the machinery in place. Now we just need a little bit of oil to smooth the process for both the courts and for attorneys providing representation in these cases, which in turn is going to ensure that survivors can safely and swiftly access this form of relief. For these reasons, MVLS is respectfully requesting a favorable report on SB 767 with sponsor amendments. Thank you so much for your time.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of Senate Bill 767 with the amendments that Senator Lee has proposed. I do want to particularly just acknowledge Senator Lee for her continued leadership in this area. It's really been tremendous. I'm not going to repeat what's been said. I will say, however, that it is very important to the Maryland Coalition Against Sexual Assault that the sponsor amendment is included, and that is that the closing of the court, the sealing of files, is not something that's automatic, but that is something that is requested by either the movement or the state. And that is because we want to make sure that we are protecting survivors, that we are not protecting kind of the courtroom, and we want to make sure that we can have court watchers present in the court when there aren't attorneys available to represent survivors. So for those reasons, we'd respectfully request a favorable report on Senate Bill 767 with the amendments.
Good afternoon, Chair, committee members. My name is Joyce King, Chief Counsel of the Frederick County State's Attorney's Office. I am here representing the Maryland State's Attorneys Association to support this bill with the sponsor amendments. Also, thank you, Senator Lee, for championing this issue and this great need. I will not be redundant as well. My colleagues have been very articulate describing the necessity of this procedural bill, and I echo the sentiments of Ms. Jordan regarding the sponsor amendments. That was MSAA's position as well, as we wanted to ensure that it would be upon the request of the state or the moving party. For a different, slightly different reason, we want to be able to ensure that we can provide adequate notice to perhaps if there are any underlying victims of the underlying charges. So with that, this is a great procedural bill that I do believe that is a housekeeping matter, and we hope and wish for a favorable report.
All right, thank you all very much. Questions from the committee? Seeing none, thank you all very much. All right, is Amanda Rodriguez here? And then we'll do Caitlin Bernitis and Mary Denise Davis. All right.
Mr. Chair, Mr. Vice Chair, members of the committee, I'm Amanda Rodriguez. I am the Executive Director of Turnaround, which is the Rape Crisis Center for Baltimore County and City. We serve human trafficking survivors, and the Legislative Chair of the Maryland Human Trafficking Task Force. The task force continues to see vacatur as a priority area for survivors, and we support this legislation because it will streamline the process, allow the process to be more predictable for survivors and less confusing for the court. Based on those foregoing reasons, the task force does ask for a favorable report. Thank you.
Good afternoon. My name is Caitlin Bernitis, and I'm the lead Maryland attorney at Amara Legal Center. Amara Legal Center provides free legal services to survivors of sex trafficking and anyone whose rights were violated while involved in the commercial sex industry. Due to the abuse, coercive control, and manipulation that trafficking survivors face at the hands of their traffickers, trafficking survivors often obtain criminal charges. A national survey of trafficking survivors reported that 91% of survivors were arrested while being trafficked. 73% reported barriers to employment because of their criminal records. 58% reported barriers to accessing housing, all due to criminal acts that were a direct result of being trafficked. Maryland responded to this situation in 2011 by becoming only the second state in the country to allow trafficking survivors to vacate or set aside their prostitution charges. In 2020, the Maryland General Assembly built upon their success, expanding the list of charges eligible for vacatur. However, with this expansion, a need for guidelines for how courts handle vacatur cases has arose, particularly when it comes to protecting the privacy of trafficking survivors. Senate Bill 797 would provide this protections. Maryland has repeatedly shown strong support for remedying the impact the criminal legal system has on trafficking survivors who are forced to commit crimes as a result of being trafficked. Let's continue that tradition by protecting survivors' confidentiality and making this a clearer and simpler process for both survivors and the court. As such, Amara Legal Center supports Senate Bill 767 and respectfully urge a favorable report. Thank you.
Questions from the committee? All right, seeing none. Thank you both very much. Thank you. And I think with that then concludes the hearing for Senate Bill 767. We'll now move on to Senate Bill 768. Senator Lee.
Thank you, Mr. Chairman. Can I have the panelists up here again for this bill? Okay, come on, guys. Okay. SB 768 is my second human trafficking-related bill for today, and the product of many years' worth of work, discussion, and feedback from all of the stakeholders. The Safe Harbor Working Group was initiated in 2015, and with the final product released in 2017, the top recommendation of the group was that Maryland become a safe harbor state for children detained for offenses related to their trafficking. Also recommended was the creation of a regional navigators who would provide guidance and resources for the survivors. At that time, the Maryland State's Attorneys Association requested that the regional navigators be created before we enact safe harbor legislation, which we agreed to do so. Our regional navigators are established, as are their resources. So now is the time to bring Maryland into alignment with the 42 states and the District of Columbia who have enacted safe harbor law or outright divert child sex trafficking survivors from the juvenile justice system. The bill works in the following way. Upon detainment of a child suspected to be involved in sex trafficking, as defined in Section 5-701, a law enforcement officer is to notify a regional navigator for the jurisdiction in which the child has been detained. The officer is then to report to the local child welfare agencies and release the child to an appropriate parent, guardian, or custodian, only if it's safe to do so, to return it to those individuals. Alternatively, a court must stay the proceedings and notify a regional navigator if an offense was committed as a result of the child being trafficked. Prohibited are proceedings against a child who committed a civil offense if the offense directly resulted from sex trafficking. Courts are still a part of the process and determine whether the offense, if one related to or with a high correlation to the child sex trafficking, those qualifying offenses listed in our vacatur law right now. 2 additional offenses, unauthorized use of a motor vehicle and soliciting, not purchasing, prostitution, are also included in this bill while not listed as a qualifying for vacatur. As discussed in the House cross-file bill hearing, some of the qualifying offenses are, of course, not victimless, and I acknowledge this, yet I must repeat that the offender is both a child and also a victim of such egregious act, and that I believe our society is better served by avoiding punishment and instead offering support and resources to the child. No crimes of violence are among the list of qualifying offenses or the 2 additions discussed prior. This bill also encourages efficiency in our courts. Their precious time would no longer be occupied by work associated with the offenses eligible for vacatur, and instead, the safe harbor requirements would be triggered and appropriate parties contacted to further assist survivors. And we waited at the request of the state's attorneys. The regional navigators are now ready, and this committee has supported initial steps towards bringing Maryland in alignment with 42 other states and the District of Columbia as a safe harbor state. So let us steer these child survivors away from penalty, instead direct them towards resources, the advocates and agencies who are really equipped to assist with the many needs of these children. Again, I have a stellar panel who do the work every day and will discuss the bill and the outcomes. For these reasons, I ask my colleagues to vote favorably on SB 768.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. 14 years. It was 14 years ago in June 2008 when New York passed the first safe harbor law in the country, recognizing what to me is common sense. Child victims of sex trafficking should not be charged with the very offense that makes them a victim. It also happened to be the first piece of legislation I ever worked on. Since 2008, 27 states and Washington, D.C. have passed similar laws providing safe harbor to child victims of sex trafficking. And other states have laws that divert cases from the juvenile justice process. That's 42 states and Washington, D.C. that have better laws than Maryland for child victims of sex trafficking. Maryland stands in an unfortunate category of not only receiving an F by Shared Hope International on their state report cards released at the end of 2021, but also was ranked in the bottom 10 states for treatment of child victims of sex trafficking. 7 years ago, in 2015, the Maryland Work Group to study safe harbor policy for youth victims of human trafficking was statutorily created. The first recommendation from the first report of the work group is to provide safe harbor for youth aged 17 and under who are charged with prostitution or prostitution-related charges with immediate referral to services. The regional navigators were established to provide services to child victims of sex trafficking, and we have long recognized sex trafficking as a form of child abuse. Yet our laws still permit those children to be charged in court. I will not share the stories of the young people who were victims of trafficking. You will hear from survivors yourself. But what I will share is that the absence of safe harbor protections absolutely prevents children from disclosing their victimization or acceptance of services because they could be subject to prosecution and punishment. Prosecution and punishment for being victimized in ways that are hard to comprehend. MNADV supports this bill not only because we believe this should be Maryland law, but because of the undeniable intersections of child sex trafficking and domestic violence. In addition to the similar power control dynamics, it is all too common for a trafficker to be a boyfriend or intimate partner of the victim. It's time for Maryland to do better. We must treat our child victims of sex trafficking as the victims and survivors they are, and we urge a favorable report on Senate Bill 768.
Good afternoon again, Chair Smith, Vice Chair Waldstreicher, and members of the committee. I am still Jessica Emerson, and I still direct the Human Trafficking Prevention Project at the University of Baltimore School of Law. I am also here in support of Senate Bill 768 with sponsor amendments. Like Melanie, I was also there 14 years ago when New York State passed Safe Harbor. My job title was different then. I was an adolescent social worker then, but my focus was the same then as it is today. I can tell story upon story of the brave young survivors I worked with back then, trying to help them cope with the harms they experienced on the streets and by their traffickers, and then at the hands of a system that was set up allegedly to bring justice on their behalf as victims of crime. There was Caroline, who had gotten HIV from her trafficker and had been charged numerous times with prostitution. There was Catherine, who reacted to her lifetime of trauma by acting out against others and was arrested multiple times for assault. There was Monique, who had been kicked out of her house at the age of 13 for being transgender. In addition to prostitution, she also had a juvenile record for theft and several other survival-based crimes. These young people all had different stories of how they got to me, but what united them was the deep, unyielding feeling of betrayal they felt knowing that the system set in place to protect them had routinely failed to do so. While they tended to view their trafficking as an extension of the abuse that they each endured throughout their childhoods, their experience with the legal system was that harming them was a conscious choice made by a system that saw them as entirely unredeemable, disposable, and wholly to blame for what had happened to them. On the off chance that someone in power actually recognized their victimization, they typically chose to use them only as a tool to prosecute their traffickers, throwing them back in jail if they refuse to cooperate. Let me be crystal clear with this committee. Incarcerating youth for being the victim of a crime that involves chronic abuse and sexual assault does nothing other than serve to tighten their traffickers' control on them and their reliance on the street. I ask that you trust the survivors of trafficking that you'll hear from today, both in person and through their written testimony, and those of us who have dedicated our lives to them. Trust us when we say that incarceration is not the way to protect these youth and that they are not more likely to cooperate with prosecutors if threatened with jail time. Do not let this body be yet another system that fails them. Thank you.
Hello to the committee. My name is Liz Kimball. I am here today not as a professional I fought tooth and nail to become, but as a survivor sharing a story I have fought diligently to put behind me. By the time I met my first trafficker in 2004, I had already been groomed for him through survival sex and parental abandonment after my father's passing. The work was effortless on his end. By the time I was 15, I was in a relationship with a man who forced me physically from his car to work on the streets in the Maryland, D.C., and Virginia area. Each night I would walk the streets in the area, taking calls from Craigslist, and I would often be brought into affluent homes, many of which I'm sure some of you in here even live in. I endured this horror for nearly a year, lying beneath man after man, being raped nearly 2,700 times. Although I wanted help, my traffickers told me no one would care. "You're the criminal," they said. "Be careful, they're going to lock you up." In addition to forced prostitution, I was also forced to commit theft to obtain survival needs my trafficker denied me, such as tampons. I was forced to fight as the culture of victimhood was commonly violent and demanded confrontation for survival. And what did the police do when they encountered me? They arrested me, calling me a whore, and they did not see me as the 15-year-old who had been raped approximately 50 times in that week alone. I don't believe they really even saw me as human. And what did the criminal justice system do when they encountered me? They held me in lockup overnight, handcuffed to another child. When I met the prosecutor on my case, they told me that in order to keep my siblings from going to foster care and my mother from going to jail, I would have to testify against my trafficker, who at the time I both loved and feared. Up and down the justice system, from the police through to the judge, had the opportunity to intervene to help and offer me protection. Instead, they simply reinforced the narrative that my trafficker had sold me, that I was the criminal. This bill isn't just about providing safe harbor to child survivors of human trafficking. It's about shifting perspective and allowing victims to tell you what we need, about respecting us as the experts in our own lives. I ask for a favorable report on Senate Bill 768. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. The Maryland Coalition Against Sexual Assault is also home to CAST, the Coordinated Action Against Sex Trafficking, and we are a group that helps coordinate the service providers at rape crisis centers to help improve the services available to survivors across the state. We strongly support Senate Bill 768 with amendments. This bill was caught in drafting delays and dropped, although we did know that it needed significant changes, so work continued, and I've been tasked with describing the amendments. Senator Lee has already described some of those. I just want to point them out for the committee. Overall, the crimes where the survivors would be offered safe harbor are not crimes against persons. So these are the same lower level offenses that this committee approved when you enacted the vacator law, and additionally some offenses that are categorized as violations. Violations are charged with citations, and they're primarily involving underage drinking, marijuana under 10 grams, salvia, drinking at schools, and gambling. It adds unauthorized use of a motor vehicle, which is one of the most common crimes charged against children who are sex trafficking survivors, to the list of qualifying offenses, and also adds solicitation but not buying prostitution to that list. That changes that for both vacator and for safe harbor. It requires that the trafficked child have committed the offense as a direct result of trafficking. So there is that nexus there, and it assigns the courts as the entity that will determine whether or not someone is a victim of sex trafficking and whether they committed the offense or violation. Finally, the definition of sex trafficking includes both the family law definition and, at the request of our colleagues at the State's Attorneys Association and the Maryland State Police, the criminal law definition in 8302. So it's very well balanced. We have a broad group of professionals supporting this, and it's an important step forward in Maryland's response to child sex trafficking. So MCASA urges a favorable report on Senate Bill 768 as amended.
All right, questions from the committee. Senator Heddleman.
Thank you very much, Mr. Chairman, and I'm not sure who the most appropriate person is, but Lisa, since you're standing, if you don't mind. So I'm just looking at the testimony, point of information from Department of Human Services and the judiciary, and they just wanted, have you had a chance to see them first?
I've not seen those.
Okay. Melanie, have you had a chance to see? So, I mean, they talk about sort of the structural issues that they have with the bill in terms of having the Navigator program do kind of an assessment about whether indeed this person is being trafficked?
Yes,
And-
thank you for that. It was corrected by the amendments.
Gotcha. Okay. And do you know if the judiciary and DHS's concerns have been fully addressed?
My understanding is that DHS is comfortable with the amendments. I don't want to speak for them, but I will say that's my understanding of that. The judiciary, I've not found the way to please them on many things,
And I understand,
so I leave that to you.
the aspect there. Okay, thank you. And actually, can I have a follow-up? Melanie, you talked about how we've sort of dropped in a ranking of where we stand as a state with regard to protecting survivors of human trafficking. Can you just shed a little light on where we are lacking?
Sure. So you actually will hear maybe on the next panel from Shared Hope International themselves, who did the report card. But one of the areas where we are the weakest is the fact that we do not have a safe harbor law. So our children can still be arrested, charged, detained, and convicted for being victims. And that was very intentional on everybody's part who worked on this bill, and all the people you were here from, to come this session only with the bill with safe harbor, because that is the very first step. If we don't have safe harbor, that's the first step in protecting child victims of sex trafficking. So thank you very much for that question. And if I may, on the question regarding the judiciary, I have seen their opposition. It was the same opposition that was submitted on the House side. And one of their concerns, one, I believe, some of the sponsor amendments address their concerns, but the process that was created to determine if a child is a victim of trafficking after a case has been initiated mirrors the process that already exists for determining competency for a child. So the same language, the same burden of proof, the same timeline, all of that was taken from existing code. And so that was just mirrored to reflect the additional determination that a child is in fact a victim and that it was directly related to their victimization. So that process was one that we took from existing law.
Thank you.
Additional questions from the committee. Ma'am, what was, I didn't catch your name. What was your name?
Liz Kimball?
Liz Kimball.
Yes.
Okay, Ms. Kimball, thanks. Well, we get a lot of frequent flyers here, which is great because to help us make sound and wise decisions, but I don't believe I've seen you here before.
I was here for the bill passing in 2019,
Got it. So
but it's been a while.
it's been a while. Well, I just wanted to say thank you for coming. I thought your testimony was particularly compelling, so thank you. All right. Seeing no further questions for the panel, thank you all. Next is, so I don't see Ms. Hanson-Mundell. Ms. Rodriguez, you're still here. Elena McWilliams, Haley Wolf, and Caitlin. Alexandra Hunter, still here? Yeah. And you can come on up, Ms. King. All right, we'll start off. Let's go.
Mr. Chair, Mr. Vice Chair, members of the committee, I am here. I'm Amanda Rodriguez again, Executive Director of Turnaround, and we were the first comprehensive victim service provider in the state to provide services to human trafficking survivors. We're also the Baltimore County Regional Navigator, which you heard a little bit about earlier. I'm also, again, the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. I was a prosecutor for 7 years in Baltimore County, where I handled some of the first human trafficking cases in the state. When I left the office, I prosecuted more traffickers than anyone else in the state had at that point. But I also faced the harsh reality that I unknowingly had prosecuted a number of children who were in fact trafficking survivors. But even me, the resident expert on trafficking, missed them. This bill will lead to more prosecution of sex traffickers. Children who are threatened, forced, or coerced to engage in the system will resist and believe the lies their trafficker told them, that they cannot trust the system. Children who are treated like victims are more likely to engage with law enforcement and prosecutors. There is a survivor who testified in one of my most impactful prosecutions, and I had to threaten her with charges to get her to participate initially, and she fought hard against me. She was subjected to regular torture by her trafficker, but she stood by him because he was the only one that she could in fact trust. When I offered her the option whether to testify or not and empowered her to actively engage, the dynamic instantly changed. We are still regularly in touch years after her trafficker was put behind bars. She's a successful woman, a wife, and a mother. A number of groups have reached out to myself and the rest of the advocates to ask questions to get clarification. As an example, the Chiefs and Sheriffs Association reached out to us with a number of questions regarding the bill. After our conversations, they had no further concerns. We have yet to hear from any group that has opposition or concerns about the substance of the bill. In fact, the sergeant on our call who regularly works on these cases says that no one wants to lock up child sex trafficking victims. We ask for a favorable report. Thank you.
Good afternoon, members of the committee. My name is Haley Wolf. I'm a law student at the University of Maryland School of Law and an intern with the Maryland Network Against Domestic Violence. On behalf of MNADV, I urge a favorable report on Senate Bill 768. This bill is important to MNADV as a state domestic violence coalition because many victims of human trafficking are trafficked by their intimate partners or someone they believe to be an intimate partner. As you heard earlier, in 2021, Maryland was ranked number 44 of the 50 states and scored an F on Shared Hope's Child Sex Trafficking Report Card because of the many improvements needed to our state response to trafficking, particularly the non-criminalization of prostitution offenses for trafficked youth. This bill is an opportunity for Maryland to catch up to the many other states who have already enacted safe harbor laws. Safe harbor laws, such as SB 768, protect children who are victims of human trafficking instead of criminalizing them as prostitutes. The best way to keep these children safe is by ensuring that they are treated as victims, not criminals. This approach encourages them to access the services they desperately need. Prosecuting trafficked children, on the other hand, can put them in more danger by not only exposing them to the harm and trauma of the criminal legal system, but also by pushing them back into the arms of their abuser, or their trafficker. Knowing that they can be arrested and prosecuted leaves child victims distrustful of law enforcement and deters them from coming forward to seek help. Additionally, what we are dealing with in these cases is not prostitution, it is statutory rape. We should not prosecute children for prostitution when, under Maryland law, they are incapable of giving consent in the first place. Even for minors over the statutory age limit, their consent to sexual acts in connection to their trafficking could not possibly have been freely given due to the fact that they have been trafficked into doing so. For these reasons, I respectfully request a favorable report on Senate Bill 768. Thank you.
Good afternoon, members of the committee. Once again, my name is Caitlin Bernitis, and I'm the lead Maryland attorney at Amara Legal Center. Amara Legal Center provides free legal services to survivors of sex trafficking. Most people think that domestic sex trafficking only involves foreign nationals. However, most of our clients are U.S. citizens, born and raised right here in the DMV area. A significant amount of our own clients began their involvement in the sex industry before they were 18 years old. And due to the power imbalance, trafficking survivors often face criminal charges due to being trafficked. This remains on the record for years or decades, preventing them access to housing, employment, and educational opportunities that can change their life. According to the National Human Trafficking Hotline, 95 sex trafficking cases were reported in 2020 alone, and with 41 cases involving minors. That's 41 bright young futures whose futures might be jeopardized by criminal charges due to circumstances not in their control. As of now, as my other testifiers have said, other states have passed safe harbor laws. Let's join that long list and join our neighbors in passing safe harbor. Under the Trafficking Victim Protection Act, all minors involved in commercial sex are victims of sex trafficking. And under Maryland's own state law, sex trafficking victims are victims of child abuse. Yet our criminal system treats these children as criminals, not victims of child abuse. This bill would remedy that and would recognize that minors, by virtue of their age, are especially vulnerable to being trafficked and should not be penalized by the legal system for their own victimization. As such, Amara urges, may I continue? Thank you. As such, Amara urges the committee to not only support Senate Bill 768, but also to expand the list of offenses for immunity to include juvenile status of such as running away from home and truancy, as both crimes are crimes that where children and youth are likely to take part in due to the power imbalances exerted by the trafficker. We urge you for a favorable report. Thank you.
Good afternoon again. My name is Joyce King, Chief Counsel of the Frederick County State's Attorney's Office. Good afternoon, Mr. Chair, Mr. Vice Chair, and committee members. I'm here to represent the Maryland State's Attorneys Association in supporting SB 768 with the sponsor amendments that Ms. Jordan so eloquently articulated. I do want to thank Ms. Jordan and all the advocates for working so closely with MSAA and law enforcement agencies to address only our technical concerns. We had no substantive concerns, but merely more technical and procedural. And through much discussion and work over the weekend, I believe that we do have the best version of this bill. In the past week, all my meetings with prosecutors and law enforcement across the state, it was unanimous. Everyone wants to provide protection, support, and services for child victims of sex trafficking. In Frederick County, we have an amazing human trafficking response team and a wonderful regional navigator, Jessica Collins, who I had the privilege of speaking with. And our county is an example of the effectiveness of the program that you all instilled. Within 48 hours, she is notified and she's able to provide these services, as well as been able in the last year to identify many child victims. So I echo the sentiments of my colleagues and believe that this bill will empower survivors and, most importantly, lead to more prosecutions of sex traffickers. So MSAA supports and urges a favorable report.
All right, questions from the committee? Seeing none, thank you all very much.
Thank you.
Do we have Elena McWilliams? Do we? No? Mikal is not here. Oh, there you go. And Alexandra Hunter. Sophie Aaron. Christina Reno. Is Christina here? There you go. All right. At your leisure. Whoever wants to go first.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross. I'm an assistant public defender in Southern Maryland, where I mostly represent youth. As the committee well knows, most children in the juvenile justice system have been exposed to adverse childhood experiences. Often, these children run away from those who inflict the trauma. And sometimes they run away to a place that may seem unsafe to adults. While Maryland law does not allow the detention of status offenders, including runaways, there's a loophole that allows these children to be detained. They can be detained for violating a valid court order, they can be detained on a violation of probation, and they can be detained for truancy when there is a valid court order. When you have youth that are already court involved, who leave home because they feel unsafe and are then forced into prostitution, scared to call for help, and worried about their safety and the safety of their family because they're told that they'll be the ones who are locked up, too often the state of Maryland proves them right. I have represented too many young clients whose stories are similar to Ms. Campbell's. Their families are looking for them. Their families would give anything to find them and have them safely at home. Their families are working with sex trafficking task forces to find their children. And then they find them, and their child snatched away from them and incarcerated, away from their family for their own safety. And detention is disparately used against young girls, but it applies also to boys in the system. The Maryland Office of the Public Defender supports SB 768, but we would propose expanding it to include all youth who are suspected as victims of trafficking, and not just those who are charged with qualifying offenses or offenses which are a direct result of trafficking. I would just end by asking the committee to follow the directive of the Attorney General's National Task Force on Children Exposed to Violence, which recommends strongly that child victims of commercial sex trafficking be treated as victims and not as delinquents or criminals. They should not be locked up in juvenile detention facilities, placement programs, or jails, but instead should be given safe harbor in facilities specially designed to address their unique needs.
Good afternoon. My name is Christine Reyno, and I am testifying in support of SB 768 on behalf of Shared Hope International. Thank you, Mr. Chairman, Mr. Vice Chair, and committee members for hearing testimony on SB 768. We are especially grateful to Senator Lee for sponsoring this important legislation. Shared Hope is the only organization tracking, analyzing, and evaluating all 50 states and DC's laws and legislation related to child and youth sex trafficking. We also provide technical assistance to state lawmakers and anti-trafficking stakeholders in a majority of states to increase protective responses for youth survivors. In this capacity, we have been uniquely positioned to ascertain effective practices and policies. Safe harbor or non-criminalization protection is a well-established, researched, and proven policy for appropriately responding to child sex trafficking victims. The majority of states in the nation have passed legislation to protect child sex trafficking victims from being charged with prostitution. In addition, many states have gone on to increase and expand that protection to include other offenses. The fact that states have expanded their safe harbor laws demonstrates the benefit to all stakeholder groups and the positive outcomes for youth. Senate Bill 768 remedies a glaring contradiction in the state's criminal code. While children who have experienced exploitation are rightfully identified as victims of sex trafficking under one section of the code, the prostitution law undermines their victim identification by treating the same child as an offender. Furthermore, innovative and smart policies and practices that are designed to protect rather than punish child sex trafficking victims, such as the Regional Navigator Program established in 2019 by the Child Sex Trafficking Screening and Services Act, are undermined when child sex trafficking victims continue to face potential criminalization for their own exploitation. I have also submitted written testimony that includes resources on safe harbor laws across the country, demonstrating the efficacy of safe harbor protections for child sex trafficking victims. Shared Hope urges a favorable report on Senate Bill 768.
I fear I'm your last witness before the end of the day. Is that true?
Yes, but then we've got voting, so.
No, I'm just kidding. Oh, I'm so sorry. I'm so sorry.
There you go.
I'm so sorry. Well, we'll get there. Good late afternoon then, Chair, Vice Chair. My name is Sophie Aaron. I'm a social worker. I'm a research and program coordinator at the University of Maryland Safe Center for Survivors of Human Trafficking, here in support of Senate Bill 768. At the Safe Center, we provide direct services to survivors of sex and labor trafficking, and we also serve as a regional navigator that you've heard about a bunch of times now for Montgomery County and Prince George's County. And in that role, it is our responsibility to help identify minor victims of sex trafficking and ensure that they're connected to trauma-informed services. And it is in this role that we have seen firsthand far too often how we are still criminalizing, victims in our community. So I'm honored to be here with so many of my esteemed colleagues. They've really hit it out of the park. We say it over and over again, there's no opposition to any of the substance here. I want to just provide one piece of data that I think really kind of solidifies and highlights how critical it is that we pass this bill, which is that between 2010 and 2020, in Maryland, there were still 110 arrests for prostitution and commercialized vice of minors. So that's 17 and under. And of those 110 arrests, 33 of them were for youth 15 and under. So these are folks who, per our federal and state definitions, are victims of sex trafficking, and we're still arresting them. And these aren't even arrests for crime committed as a result of trafficking. These are arrests for prostitution and commercialized vice. This is an unacceptable response. What these kids need is child welfare. They do not need juvenile justice. As my colleagues have mentioned, this would build upon our 2019 Child Sex Trafficking Screening and Services Act that provided services. Now we're going to provide some further protection for these minors which is critical and much needed. And for these reasons, the University of Maryland Safe Center would request a favorable vote on SB 768. Thank you very much.
All right, there you go. Thank you very much. All right, questions from the committee? Seeing none, thank you all very much. With that, that'll end the testimony and the hearing for Senate Bill 768. That'll also end our hearings for the day. We're going to take a 15-minute break. We'll come back and vote.